Someone make it make sense.
Probably a couple.
Hello, young lovers, wherever you are. How about we start each show with a show tune? For some reason, that song has been stuck in my head. I think it's from The King and I. I don't remember what's after that. I just remember the first part. So, how's everybody doing tonight? Let's see what's happening. You're not in the wrong place, wifey. You're in the right place. STS has a show going on right now, and Larry Levine is on, and so it's running longer than usual. But I was restarting my computer, and so that's why I pushed the time back. But there were some people that I even saw in the chat that were commenting about the live stream. I think they'll be here. You're not in the wrong place, wifey. So yes, indeed. And tomorrow we have another stream for Gloria Satterfield. And I believe that one is at 7:00. So we will have, we'll pick up where we left off with that. Nightbot had a message. I love you, Triple R wifey. So I hope y'all had a good day. There's been a lot going on. My goodness. We had 2 trials with testimony today. Some major testimony happening out of Idaho, speaking of which, with Chad Potato Daybell, because Heather Daybell took the stand. And one thing that really stuck out to me, I wasn't able to, I just was mostly listening, but one thing that was really crazy to me was that there's been a rumor, or not a rumor, there's been talk from people who know, who are in the inner circle, as it were, that had been thinking that Julie Rowe and Chad had some sort of thing. Like, I don't know what to call it, just a thing. Like, Heather Daybell, wifey, is, she did an interview with Hidden to Crime. So Chad's younger brother, Matt, Heather is his wife. And it seems like Chad was always really kind of, I want to say, afraid or intimidated by her. Like, she was definitely on the list, like the dark list. Like, he did not like her. He feared her because she had a solid read on him from the beginning, and she's a fucking awesome. Like, we would be friends with her in real life. Like, she's fucking amazing. So, and she did not testify in Lori's trial. And so anyway, but there's been talk about Chad and Julie Rowe, but in my opinion, there was nothing really there to back it up. I'm not saying that anyone was, it's just that it was like, people are trying to be careful. It's not like I'm saying that people are making it up. That's not what I mean. I mean, the information is coming from solid sources, but people are being really careful, which I understand. Part of that is because a lot of them might have to testify at trial. So there's been like kind of like whisperings about it. I feel like today here was the earth-shattering moment for me so far in Chad's trial. Not only did Heather clarify about the staircase non-issue in the house, that wasn't an issue until Pryor tried to make it an issue, told a story about Chad and Julie and talked about that. And I was listening to it as I was doing other things, and I was like, holy shit. Holy shit. That was like an earth shot. Like, that for me was the first time where that notion had any type of legs or credibility, like real deal, like, because now we're hearing it directly from somebody who's on the stand, who's under oath, and it came out on cross-examination. And dude, that cross-examination was a dumpster fire for Pryor. That was like, what are you doing? And it was crazy. You could tell he was afraid because he was objecting to everything on direct. And then when it came to cross, he was like, I don't know what he was thinking. Was he thinking he was going to gain some sort of ground by asking more questions? It's like with each question, it's just getting worse for you. And then the best part was at the very end when Judge Boyce was like, State, are you going to recall this witness? And they were like, no. And then they were like asking Pryor, because I guess Pryor initially had her under subpoena also, as in they might call her as a witness. So they're like, Pryor, are you gonna call her? And then he was like, no, I think not. Wait, what do you want me to repeat, wifey? But it was really funny because it was like, of course you're not. Like, that was a fucking disaster. Repeat. Oh, Heather Daybell was talking about on direct examination, one of the things that she noticed about Chad that was a red flag to her was him with Julie. She said something about how Julie like came and stayed at their house or something. She didn't say anything like, oh, they had an affair or blah, blah. It was similar to what we've heard before. It's all shrouded in like veils of, Mormonism. You know what I mean? It's like, how did she say it? She said something like they were talking and their faces were close, something along those lines, right? Where in normal life, that means nothing. But in this life with them, it's a red flag. Like they read it as a red flag, but like it's a red flag to us because of them mentioning it at all. And so like the fact that she said that, like, it's the type of thing where it's like, if you didn't already know how to understand the way people talk about these things, exactly, you'd be confused, right? You'd be like, why are you even mentioning this? This doesn't make any sense. You're just saying they talk with their faces close. It was something along those lines, right? It might not even have been that bad. It might have been more innocent than that. It was like along those lines though, where it's like, if you didn't know what to listen for, you'd be like, what? But if you know what to listen for, you're like, oh, like, I think I was like, I don't remember what I was doing. I dropped what I was doing and like ran over to the TV and like stood there with my jaw on the floor. So, and I don't know. I think Julie and Chad stayed at Heather and Matt's house or something. Again, I was doing something else and I was like half listening until that came in. And I don't, again, it wasn't like she said anything about them having an affair. It wasn't like that was even hinted at. It was like the important thing was the read that she got on it was a red flag to her. And she's genuine and believable and credible enough that you pick up on the red flag from her, even if you don't understand fully the context. So that was huge. It was just the first time where we heard somebody say that out loud, because other than that, it had just been kind of like, I don't know, rumor is not the right word. It had just been something that had been kind of in the background, but I had not heard anybody say that, Okay. Yeah. I mean, and I don't remember exactly if she said they stayed overnight. I think she said that they stayed overnight. I don't know for sure, but then there was something else she said that they did, and they were just, their faces were closed or something. Again, I was, I just, for everyone, if they're listening, hopefully you saw it, or you can go back and watch it. So that way, if I'm not saying anything verbatim, I'm making that clear, but what was clear to me was Heather got a vibe of, and in the way, let me add it this way. Where this came up in the line of questioning was they were talking about adultery, because what happened was, okay, here's what happened. This was very exciting. What happened was, on direct examination, she was asked, sorry, hold on. It was on redirect. Sorry, it was on redirect. So there was this cross that was brutal as in for Pryor and Daybell, like this was just, it was, yeah, it was bad for them. And so on redirect, I think it was the very first question asked on redirect was something like, I think it was the first question. And it was like, under the Mormon doctrine or whatever, it's like, is adultery allowed or something along those lines, right? Like right out the gate, like said it really direct. And I was like, oh shit. And I think what happened was, I think Pryor objected, but his microphone was on mute still, because he's basically Elaine from Debbie Heard. Because initially I was like, wait, what? Because the next thing I heard after that question was, I heard Judge Boyce say, sidebar now. And I was like, oh shit. And this is before this is stuff about Julie Rowe. And so then they have their sidebar. And then again, I was in a different room of the house, I was listening. And then I hear Judge Boyce come back and he's like, okay, and he refers to an objection. So that's when I was like, oh, Chad must have objected, but his microphone was off because he's Elaine. And then he's like, okay, counsel, ask your question again. And I thought, oh, he's going to have to rephrase the question, right? Because normally that's what happens. Dude, I forget his last name. It's the prosecutor. His name starts with a W, Wicker or something. And he asks the question verbatim the same way. I was like, balls. Yes, yes, yes. He asks it as if no time has elapsed. Same tone, same pacing, same diction and enunciation, same volume, same exact wording, exact question. Yes. Oh my God. I was like, get it. Get it. Yes. Yes. And I'm like, wow. And then I was so floored by that honestly, I don't even remember if Pryor objected or not. But if he did object, it got overruled. And I was like, yeah. So the question came in, and then she was like, yeah, no, that's not allowed or whatever. And then it was in this line of questioning about adultery that the thing came up about Julie Rowe. Dude, it was insane. Did you guys see this? I wonder, did you, DSN, did you see this moment with the adultery moment? Also, we do have this. Do, 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 do.
Hey, he's got burgers now.
Woo!
This is a chicken.
Woo! That was so sick though. Like, so anyway, but it was crazy. Like, I was really impressed because I have not seen the prosecution, and I don't even think in Lori's trial. It's always been very mild-mannered with all these attorneys and the Vallow Daybell shenanigans. They've been very mild-mannered. And this was the first time where I hate to say this. This is the first time where I was really impressed because that was ballsy as fuck and in a good way. Like that prosecutor, Mr. W, whatever, Wicker or whatever, like he only could do that if he knew that it was either going to not be objected to or it was going to get overruled. Oh, hello, need some Z's. Happy to see you here. I'm trying to think if this is someone that why is that picture? Your picture looks familiar. So I'm happy you're here. And yes, so I've been following Karen Reed also, and I'll just do a little brief. There's a lot going on because there's like, there's Karen Reed, there's Daybell, and then oh, awesome. Well, thank you. I feel like I just recognize your thumbnail is very unique and it looks familiar. So I feel like you've been here before, or you've commented, but I just remember the thumbnail. Looks like it's some sort of knitted or crocheted figure, but I just remember that. So yeah, there's Daybell, and then of course there's Karen Reed, but I'm also doing now all these filings in Idaho, and then of course there's the deep dive on Gloria Satterfield. But my thing with Karen Reed, as you guys know, is that I'm allergic to her face. So, and I'm also allergic to toxicity and divisiveness and, people being immature and people judging and fighting and missing the point entirely. So I've not been involved in all the pre-Karen Reed bullshit. And so sadly, even though the trial has started and the trial itself is fire, literal fire, sadly, some people are still caught up in talking about the bullshit, and it makes me sad. But anyway, the trial itself, like, dude, the fact that every day started with hear ye, hear ye, hear ye, and then what is it? God save the Commonwealth. Yes. Bravo. My favorite already, right there. But okay, cool. Well, that's awesome. I'm happy you're here. But yes, so I have been kind of my days have been so crazy because I'm kind of like bumping back and forth, like bump, bump, bump between the 2 trials, and then of course doing getting my own stuff together. It's just the mouth. It's just the mouse. I said that because I'm using my mouse as the mouse that I keep talking about now because it's brand new to me because I just found it. But it's something about the lips. I don't even know. I can't. It's distracting. There could be anything else. There could be anything else happening in the background. There could be a room full of squirrels. There could be a bomb going off. There could be a rocket plane launching or whatever, rocket ship. There could be anything happening in the background, like literally anything. And if her mouth is anywhere on the screen, all I can see is the mouth, and it's very distracting. So it's just a distracting mouth. But, you really don't need, I'll say this much. I've done a lot of trials through mostly listening, and don't do it. Your eyes will fall out of their sockets if you do that, wifey. They'll fall out. But, you can get away with listening to the majority of trials a lot of times, I think, depending on which trial. But usually, for me at least, you can tell if they're watching the video, if there's some sort of exhibit. And then at that point, if I can, I'll go and look at it. You know what I mean? But I don't even know about an RBF. It's just the lips. It's just the lips. It's like, I swear, it looks like a physical disability to me. I'm not trying to be mean. It looks like I can't make my face I can't make my mouth do that. I don't know how. And it never changes. Like, that's the other thing. It's like, it looks like, does she, okay, let me put it this way. It's like her mouth is stuck like that. Like, how do you eat? How do you eat? I don't know how you eat if your mouth is stuck like that. That's very astute of an observation, wifey. Thank you. It is hard for me. I don't know why her face, it's just, I don't understand it. And part of it is that it doesn't move. Like, if I learned that, okay, if I learned that there was an explanation, like her face was wired like that, like wired shut or like super glued or whatever, I think it would still be hard. It's still visually still so distracting for me. I don't know. I'm thinking maybe I could try, but I couldn't promise anything. But again, I don't feel like by not looking at this, I'm missing out. Like, I don't, you know what I mean? Like, what am I going to benefit? Like, again, if there's videos or exhibits, like I'll either try to go see it at the time or I'll go back and look, whatever. But it's just a weirdness. Yeah, I don't. But see, they have to open for that though. Like, see, wifey, that's the thing is, like, you're talking about lips that open. I don't know. I don't know that they open. Is there even? Don't go look, guys. I don't want you to hurt your eyeballs. But is there even a picture of her on the internet with her mouth open? I haven't seen one. If it exists, I have not seen one. But don't go looking because I don't want you to injure yourselves. So yeah, and for you, need some Z's. If you were falling for Murdoch, we're doing the Gloria Satterfield deep dive, and it's insane. It's actual insanity. And tomorrow will be the 3rd episode. We had so much fun last night, guys. That was awesome. I appreciate y'all for making me laugh so much. My face still hurts today. From that. So, okay, I believe you. Again, I'm not going to look because of safety purposes, but I believe you. But are they open though? Is the mouth open? Because you can smile without opening your mouth. I mean, just saying. Look at this picture. I don't know. It's something weird. I mean, having said that, it's not nearly as concerning as whatever is going on with her face is not nearly as concerning as what's going on with the Commonwealth. And I'll quote wifey from aka Triple R wifey from the other day. What she was saying to me was something akin to how are you the DA and how are you not resigning right now after the defense is opening? I think that's very accurate. She was very well put. It was very well put because I was telling her, I was like, you got to go watch the defense's opening statements. And then she did, and she comes back. She's like, dude, I mean, she can tell you because she's here in the chat. Like, she's like, dude, and then her reaction to it was like just exactly correct. You know, like, how can they walk in the courtroom? How can they show their faces on planet Earth? That type of thing. Yes, accurate. All of that's accurate. So, and I mentioned this the other day, and it happened. It's been getting worse, actually. It was getting worse even today. There was that female first responder on the stand, and what you don't want is this in a trial, right? What you don't want is this: is you don't want your witnesses to be confused by the questioning. And I said this the other day because I was thinking to myself, I'm confused by the questions. That means the jury's confused, but on top of that, the witnesses are confused. It's been getting worse, where the witness is like trying to answer the question, but they don't understand the question because the question is utter nonsense. And they're not hard. It's not like it's a hard question. All these questions are like, redundant because they've already been answered by other witnesses. They're just foundational, and all of them are about the fucking weather for the most part. But like, instead of just saying, what was the weather like? It's like, it takes 50 questions to ask that, but it's in a convoluted manner that no one can understand. And dude, nah, don't ever apologize. We love it here. We're all about derailing and tangents. It is okay. And I'm happy to see you. Please don't apologize. There's been so much going on with these other trials. I've been beginning every recent live stream with talking about, if it's not Karen Reed or Daybell or something from another live stream, then it's then like it could be something like yesterday, where yesterday we started with my what happened at the Kohl's story. Kohl's as in the department store. So basically, if you guys don't give me something to derail it, I'm just gonna come up with something on my own. Either some sort of funny story or or something. We've had a lot of stories. We've had the bear story, we've had the knife wielder story, we've had the Outer Banks car van story. We've had a lot of stories. You guys still haven't heard the tow truck story. Don't worry, I'm not forgetting. And then we had what happened at the Kohl's. We got a lot of stories. So don't ever apologize. I'm glad you're here. And you're in the right place. So we love it. Yes, 100%. That was one of the best opening statements I've seen probably ever. I think it's probably tied for me with like Mark Eiglarsh. Shout out to Black Widow representing, not her choice, but mine, the Republic of Ireland. Did any of you guys see Mark Eiglarsh's opening statements? I'm not going to say what case it's from because I have a plan for this. I'm thinking we might watch his opening statements. I don't want to spoil anybody by telling them what case it's from, but it was not well followed. I will say that much. And I wouldn't be surprised if you guys don't even know who I'm talking about, but it was underappreciated and underfollowed, in my opinion. And for me, it was one of the best opening statements. And if you appreciate the fury that Karen Reed's defense hath brought into that courtroom for the fuckery, the fact, the audacity that this case was brought against her and all that, you will appreciate what I'm talking about with Mark Eiglarsh. There's a lot of similarities, although there's no Boston. Hi, Copperhorse. Shout out Copperhorse. There's no Boston, but all the fury as well is still there. So, y'all, let me know if you are. I'm going to type the name in the chat of the attorney I'm talking about. Again, the point that I'm making here is I would say that if I had to try to think of in recent memory my two favorite opening statements, it would be I don't even fucking remember his name. I know DSN knows it. But Yannetti, was it? Karen Reed's defense attorney. Again, I did not follow it prior to the trial. So there's that. Karen Reed's defense attorney, and then I would say Mark Eiglarsh, and they would probably be tied for me. And what's funny is both of them are defense attorneys. But there are a lot of similarities. But I've been toying with the idea of actually kind of putting it together of us, maybe if we feel like it, watching Mark Eiglarsh's opening, since I figured you guys probably did not know who it was. I like I said, that doesn't surprise me. Very few people appreciated this trial when it was happening and appreciated him. So what I would do is if we want to watch it, I wouldn't give you any information. We would just start watching it. And then we would go through and assess it like from a clean slate, if you guys want to do it, let me know. I think it'd be really fun. And it's something that I've been toying around. What gave me the idea actually was when I saw Karen Reed's defense of Yannetti, when I saw Yannetti's opening, I was like, it reminded me immediately of Mark Eiglarsh. And I was like, oh my God, we should probably watch his opening because I know that no one watched it. And so I started thinking about that idea at the time. Cool. So yeah, so that's something we can totally do. The only shitty thing is that the audio quality isn't very good, but I might see what I can do. And also, by the way, you guys, Spacey, who's not here right now, but he is doing us all a big favor. I'm fairly certain. Exactly. He's doing us all a big favor right now, you guys. He's working on the Gloria 911 call. Remember when we talked about this? Because that 911 call, no one has done anything with the audio on that. And that's why there's not even a transcript, an accurate transcript. Remember we talked about this? It's like, it's just guessing, right? There's parts that are really crucial that you can't hear. And he's working on that. He's working on that for us, the audio. And yeah, tomorrow's Spacey's birthday, but that's going to be huge, and that's going to be a huge thing for us to have, and for everyone to have. Like I said, YouTube deserves to be able to have access to hearing that, and the fact that it's fucking sad, right? That nobody's bothered until now, right? Like, of all the people on the internet, it's just no one's thought it was important enough or something. And it's just fucking depressing. If I could do it, I would. But I appreciate that he's going to do that for us. So, I told you, he was like, when do you need it by? I was like, absolutely whenever, there's no deadline. So I don't know when we'll have it, but that doesn't matter because when we have it, we'll be happy to have it. So, yeah, so I know Karen, his first 4 words. Exactly. Yeah. So, okay, let's jump into this hearing a little bit. So there was so much this was going on, right? Speaking of all the other stuff that was going on today, so was this hearing at the same time. And my expectation was that it was going to be like,
for the state, we have.
Let me pause it. My expectation was that it was going to be short. It was about an hour long. Yeah, I know I told you this before, but like as a musician, I can just say that it's just it's like nothing that no skills that I have in life would help me even begin to do any of that. Like, it's just a whole other thing. It's like, I don't even know, navigating an underwater cave that's black or something. I don't even know. I'm trying to think of an example and I can't really think of a good one. But it's like, unless you know how to do it, you're fucked. Like, I mean, you know what I mean? Like, essentially, it's just a whole thing. And to do it to a good level, right? Like, anyone can like boost the volume or whatever, but like to actually make a big difference in if it's audible or not, you know what I mean? It's just, that's a whole skill set. So, but yes, so this hearing happened while there was millions of other things happening. Actually, while this hearing was happening, Chad's mom was on the stand. I remember this because I'm like, I can't watch all the things at once. So Chad's mom was on the stand in Idaho. Meanwhile, in Idaho was this hearing. And meanwhile, in Boston, they were getting ready to wrap up their half day because of the time zone difference, if memory serves. So, okay, let's see what this has in store for us.
Mr. Thompson, Ms. Jennings, Mr. Nye is participating remotely, and I don't see Ms. Davis. So
people are haters about him. I love Judge. I'm a fan.
I have a few things just to sort out today.
People are haters.
The first thing I want to talk about is whether or not this hearing should be sealed. What's your position, Ms. Taylor?
Your Honor, this hearing should not be sealed.
Okay. Mr. Thompson? Ms.
Well,
Jennings?
Your Honor, the state's prepared to do its argument today without.
Mr. Thompson, aka Santa, but he ever since that that hearing with the jury survey thing, I know I've talked about this before with wifey at least, but that in my mind I'm like, oh, he's not Santa at all. He's mean and mad. he's forever the type of Santa. He's like a mad Santa or something. It's really funny.
Actually talking about the specific request that we're trying to protect within the discovery request. And so as long as those specifics are not discussed or mentioned, then I think we can go forward with an open hearing today.
Okay. Are you comfortable with that, Ms. Taylor?
Yeah.
Well, what I'm not going to talk about is the content of the court's protected materials that we've asked for a sealed hearing.
Quick recap. Let's see what you guys remember from last time. All right. So this would be from, I did the little video premiere from like, what was it, yesterday? And then I don't remember. I've been doing so many videos and live streams every day this week that I can't keep it straight. It's been insane. But whenever the other one was the live stream where we went over the 50 million motions in one day, or not motions, but different court filings. Some of them weren't motions, but so what do you guys remember about what we talked about? Like, what's this hearing about? Do you guys remember? Do you guys remember what the different matters that were at issue were? Do you remember what they were talking about? The things that were going to be potentially sealed? What do you guys remember? Being a teacher, it's like I prefer to see if people can remember versus me just telling people things. You know what I mean? What do they say about the brain? It's like a parachute only works when open, what have you. Yeah. And wifey, you don't have to put me in the true crime category if you don't want to. Just saying. You can put me in the squirrel category if you're going to put me in a category. I know what you mean, though. I'm not saying that you meant anything. I'm just, That's correct. DSN. Yes, you get a point. That's correct. That was one of the things. What else? What else did we talk about? Or even if you weren't there, do you know? Like, remember it's jog y'all's memory. I'll give you a little hint. So they talked about Rule 32G from the ICAR, which is the Idaho Idaho something administration rules. I don't blame you. I know that's you're not alone in that for sure. Okay, so we talked about, remember, I speculated as to what some of the matters were going to be, that there was going to be two main issues because we're talking about these upcoming hearings. What they're going to be talking about today is these upcoming hearings. There's going to be one on May the 14th and one on May the 16th, and if they should be open or closed. And remember, the state made a motion to have it sealed, and then the defense objected. Okay, and then after that, they had a little compromise between the two of them without judge. The children got along. The children had a little chit chat and they decided, okay, we're going to compromise. We're going to say that May 14th can be open and May 16th should be sealed. Now, remember, my speculation at the time was that these were going to be on two matters. One was going to be the alibi, which is going to be cell phone shit. And then the other is going to be IGG. And that the IGG is the stuff that they're saying should be, it's the defendant's fourth and fifth motion to compel, right? And my guess is going to be IGG, and that's what that's regarding what the state is trying to have sealed, that hearing, or closed rather. So, but what's interesting is it's usually the other way around, isn't it? Like, think about that, guys, right? When you think about okay, let me ask you a question. Let me do this better. When you guys think about who is it in any trial, who is like, my job, it's about protecting the defendants or the accused, the defendant's rights to a fair trial, due process. Who do we always hear that from? Let me know in the chat, because that's important. Who do we always hear that from? That the number one goal is protecting due process. That's more important than the right to a public trial, for example, let's just say that's what matters more. Like, a public trial is important, but it matters more that we protect the accused and correct. Becky Hill, LOL. Me, defense. That's what I was thinking. The defense, right? always see the prosecution, you know, wanting things typically out in the open, typically. And then the defense saying, no, we need to protect their rights. And that's true, right? Ann Taylor is 100% all about protecting Kohberger's rights. Here's what is so crazy that we're going to hear. This is going to be all flipped on its head in this hearing. From the little bit that I heard, because I was doing millions of other things, this is all going to be flipped on its head.
What I'm prepared to talk about is why should we seal this particular motion to compel that's set to be heard, and how much else.
So remember, with that context in mind, remember, the defense initially objected to anything being sealed for these upcoming hearings, and then they compromised with the state. But they're here, this hearing is to discuss this, the headbutting over, not sealed, but closed or not closed, these hearings, closed or not closed. So now we're going to hear from Ann Taylor, okay?
Else is in the public record, and why there's no compelling reason to seal that, and why that violates Mr. Kohberger's constitutional rights. So if I talk about things that are in the affidavit, and if I talk about things that we're seeking that the state wants to hide, I think that's fair game for the public to hear.
Your arms off.
It's the challenge here is that both sides have agreed to seal all the discovery. There's a lot of stuff out there. And so I hope that you can both honor that at this point, because down the line, maybe some things do have to discuss. We need to discuss very specifically that maybe both sides don't want that out in the public, because it is a fair trial goal here. And if we start arguing about the case itself, the trial, and the evidence that you're gonna present, both sides, gets more complicated.
You see what he's saying?
Maybe
What he's saying, if you had to try to read between these lines, is we have to pick and choose how much shit we're going to argue about, because literally the law is arguing. Literally arguing over everything. That's their jobs. And so he's like, we kind of have to pick and choose here, because it's going to be the year 40, 45 of our Lord before this goes to trial if we argue over everything.
Prejudicial to one or the other. So I guess at this point, we'll keep this open.
You're all going to be skeletons.
Be careful. I mean, I've read everything, so I know what's sort of out there and what you're concerned about, and some of those materials or potential evidence could be prejudicial to the state, or it could be prejudicial to Mr. Kohberger. So my job is to try to keep on a balance here, a neutral balance.
Technically, this whole argument that's occurring right now about the hearing was the prosecution's doing, because the hearings are open by nature. By definition, the default for these hearings is they're open to the public. So let me just make this clear for anyone by default, the hearings are not closed. By default, they're open. So in terms of when we see all these legal filings that come in, they have to make a filing for everything. In other words, they have to go out of their way to try to get it closed. So that starts by making a motion with a legal filing. And then when that happens, then the other side has to respond. It's what's called an answer. They have to answer to that. And that might go back and forth or whatever. And then they have to schedule a hearing, like what we're seeing right now. And then they have to have the hearing. So if the prosecution did not make a motion for the upcoming hearings to be closed, we wouldn't even be here right now.
Where when we get to the trial, if we ever get there, that it'll be fair, and we'll have been determined in advance. Okay, so keep it open today. If something comes up and we need to close it down for period of time to discuss a particular situation, then we can do that. Okay, so it really, I think at this point, it's the state's motion to close the hearing completely on
we're not here because of the defense. We're here because of the
May
state.
14th. I believe, I'm not incorrect, that you both have stipulated to closing May 16th, which is related to the IGG.
Your Honor, our position is that's the only part that should be closed, and that's because we want to talk about the content of the court's, the materials protected by the court's order. And
So here's what I was saying, though. Remember the question I was just asking? Here's what's so crazy about this whole situation. It's flipped. Typically, like we were saying, what we normally see is we see the defense being like, hey, let's keep this closed, blah, blah. In this case, as we saw from those other filings, we read through that whole day for like the 50 million filings. This is the opposite. It's very unusual that we see, hi, Tennis Girl, happy you're here. It's very unusual that we see the prosecution making these motions to have the hearings be closed and the defense saying, no, we want them open. They're objecting. They only agreed to one of the two hearings as a compromise to minimize the arguing, but they wanted it to be open. So this is very unusual.
that one's appropriate to close.
Okay.
My experience.
Okay, I think I'm on the same page, but great. Okay, Ms. Jennings.
Then.
Thank you, Judge. So, Judge, the applicable.
Oh, also, I wanted to say, you guys know Iowa Backyard Cam. I made a command for, I don't know if it's a him or her, but I made a command for them. And also, I did check out their live stream today because they have so it's a channel with like, the live streams are just, it's awesome. It's just a camera in the backyard with all the animals. Dude, it's awesome. You guys, like, it's really good. And it's just it's squirrels and chipmunks and birds and all the animals. And you know what's so great? The music that they had playing is night driving. Just so you guys remember, I'll remind ourselves what night driving is. It's what I use. This one. Yes. So chill. So I was like so excited. I was like, night driving. This song. So they use night driving. And so if you haven't yet gotten a chance, check out their channel Iowa Backyard Cam. And one thing I was thinking too, is that it will be good for like if you guys have pets and you're gone for the day or whatever, you know, there's like you can like leave the TV on and stuff. This would be heaven for pets to have this backyard cam. It was really good. So that was just another thing I wanted to remember to say. So Wifey says, I don't want them to be on the same page. This is weird for the prosecution and the defense to be agreeing on so much. Well, they're disagreeing. What do you mean on the same page, though? Because they're disagreeing. The prosecution wants the hearings to be closed and the defense wants them to be open. They're disagreeing. That's why they're here. If they agreed, they wouldn't be here. They did kind of make a compromise on that one out of the two hearings, but that was the defense compromising, in my opinion, being the more mature of the siblings, if you had to ask me. That's awesome. That's awesome, Abby. So yeah, the prosecution didn't budge. It is weird though, right? Like let's just check our biases. Let's check our biases, guys. If the defense, let's do this. All right, because we've seen this. Yes, Wifey changed their name. Abby, yes. I'm sorry you didn't know. That's Triple R Wifey. Abby didn't know. She's Triple R Wifey now. I'm so glad you picked up on that. It's awesome. Yes, she did. She changed her name. See, she's Triple R Wifey now. Let's check our biases though, guys, please. I think it's important. So imagine if this was the other way around. Imagine if we knew there was hearings coming up, because we've seen this before. There's hearings coming up on the IGG stuff, right? The investigative genetic genealogy. and the defense was making the motions to have the hearing sealed to the public. What would you guys think about that? Yeah, I understand your confusion. I am so sorry. I forget who knows and who doesn't know. I understand your confusion. That's completely valid. I'm glad you understand now. You're okay, Abby. You're okay. But what would you guys like? Again, we've seen it before. So what if it was the hearings coming up? They're going to be on cell phone evidence. They're going to be on IGG. Use your thinking or your imaginations, guys, and imagine what if it had been Ann Taylor who had filed the motion and said we want these hearings sealed. What would we all be thinking? What would be the status quo, general consensus? That's the word I'm looking for. What would be the general consensus, the general attitude, if it had been the defense who made the motions to have the hearings closed to the public? What do you guys think? Normal. Okay. Would people be happy, pleased about that, or displeased? Would people be like, that's sus? I mean, it would be normal. I agree. But people still, in my opinion, complain about it. Yeah, I agree. Displeased, right? They'd be like, what are they trying to hide? Right? Yeah. That's what I mean, that's what everyone would think, right? What are they trying to hide? Why do they want? Because for this reason, it's supposed to be public. And we know that. It's supposed to be public. So yeah, and that's the thing that I think is really important is we need to make sure never, you guys, if I could, exactly, what are you hiding? Yes. If I could wish, I have a lot of wishes for you guys in your lives, but one of the things I would wish for is that you never lose your sense of curiosity and that you're never afraid to ask questions and be inquisitive. And so, and to not just, you know what I mean? Like, yeah. So, so does that make sense? Like, because we have to actually think about these things and that we can and take a step back and see things like from that objective perspective, like the third eye, like, yeah, displeased. Absolutely. Yeah. So I would be displeased, but here's the thing. I'm just as displeased if it's the prosecution. Like, because basically whoever is arguing, whichever side is arguing that it should be public, in my opinion, is usually correct. Only in maybe rare circumstances, like for the protection of victims, when you're dealing with things that maybe exposing names, certain things, okay? Certain things, okay, fine, right? We know, like with, for example, like the Ruby Franke stuff, there's stuff where it's like, okay, yes, we need to have that. That doesn't need to be out in the public, blah, blah. But for the most part, I think that whoever is arguing that it should be public is correct because technically they are, like, that's what the law says. And so that's why I was saying, that's why I specified, remember, the default is that it should be. That's the thing we have to keep in mind. The default is that it should be open, public. You have to go out of your way to make it otherwise and to make it closed. So it's interesting that in this case, it's the prosecution, or not in this case. I mean, in this case with this particular hearing, right? Again, it's gone other directions, but right now in this particular hearing with the upcoming hearings in May, the prosecution wants it closed and the defense wants it open. And I just find that so fascinating. And I think it's just important for us to not let that go unnoticed, because I'm not saying we need to be displeased with the prosecution or whatever. I'm just saying it's something that just to keep ourselves balanced. You know what I mean? And to kind of check our own like, what's a good way to put it? Like how they talk about like echo chambers and stuff. Like, I don't use social media, but I know that one of the things that people have talked about, Gary Brucato for one, with social media, things become echo chambers. So people end up grouping with people who they already agree with, and then they all feed each other's opinions in the same direction. And what happens is it's like you stop using your critical thinking, I feel like, and you tune out everything else. So has anyone looked into the mother and mother-in-law of the two victims? I don't know who you're referring to. Emma, isn't that one of Chad's? Are you referring to one of Chad's daughters? I'm not quite sure. Demetrius? Honestly, I don't know who you're referring to. But if you can be more specific, I might be able to answer your question. Or someone else in chat might know. So anyway, I just think it's important that we, what's the right way to put it? Just stay level-headed and use our critical thinking skills. And again, don't lose our sense of asking questions and our sense of curiosity.
Authority today in determining whether or not we should close the May 14th hearing is Idaho Administrative Court Rule 32 and Idaho Code 74-124. Both contemplate balancing this public right to an open hearing versus the interests such as privacy, safety, and the right to a public trial or to a fair trial. Now, deciding whether or not to file the motion to close the
remember, she's arguing. I've not seen much of this lady before, so let me just say real quick. She's arguing for the prosecution, and she's going to argue that it should be closed.
Hearing, the state weighed those interests and ultimately came down that the need to protect the privacy and the sensitive information and ultimately protect the state and defendant's right to a fair trial outweighs the right to an open hearing.
I mean, it's just not believable in my opinion. How many times have you guys heard a prosecutor making their argument on behalf of the defendant and their right?
Feel confident that when the court does the same balancing test, it'll come to the same conclusion. For the record, since the beginning of this case, attachments detailing the specific discovery request have been filed under seal. In line with this, on April 4th of 2024, just about a month ago, the state and defense filed a stipulated motion to file all future attachments under seal. Today, we're specifically discussing the defendant's fourth and fifth motion to compel discovery. Concurrent with the defendant's fourth motion to compel discovery, the defendant motioned the court that the details be filed under seal, citing Rule 32. Concurrent with the fifth motion to compel discovery, both parties stipulated to filing the details under seal, citing Rule 32 as well as Idaho Code 70.
Yeah, so that's Ann Taylor's job, is to argue on behalf of the defendant. Why it's weird is when the prosecution is arguing on behalf of the defendant. Do you feel me? That's weird. It's like an own goal. That's what Runkle would say. It's like an own goal. It's like, hey, you're on. You forget what team you're on? You know what I mean? Like, when you hear the state saying we're filing this motion because we're worried about the defendant's rights, and all that. It's like, what? I mean, they should be worried, but that's not, every prosecution knows that that's what the defense is for. So Need Some Z's says, in my opinion, why the state is freaking out all has to do with who gave them Bryan's name and what they gave them for it, and then worked backwards and used IGG against their rules. Could be. I mean, there is a reason. Here's the thing. There is a reason. You might be onto something there. There's a reason why the state wants this closed. And here's the thing, like we've seen this in other cases, right? In other cases, when does the state want things closed, guys? Like, what do you think? Or the prosecution, right? In cases of, when does the prosecution want things closed to the public? Typically. I mean, that's really what it comes down to. There's a reason why the default is open. Like I keep saying, there's a reason why the default is open, because even if there's nothing fishy going on, transparency is really important. And the burden is on the prosecution being the government. That's why that matters, right? Why do we see the defenses typically being the ones who say they want it closed? Well, because they're not responsible for making the citizens feel like they can trust their government, right? It's a defense attorney. The prosecution, however, is people's trust in the government and all that. It's all tied together. And political cases or sensitive cases for victims, hopefully. Yes, true. But I mean, I guess I'm thinking more along the lines of like Delphi, just in recent memory, in terms of when things have been kind of kept away from the public. But there's other examples. I just can't think of any right now because there's so many trials going on. But like, there's been other examples too, where things have been, the prosecution has tried to keep things out from the public, right? And I'm not saying anything fishy is going on, but what I'm saying is this. What I'm saying is that part of the reason why you want things open is because it can give people that feeling, right? Because it should be open. It's all about that transparency. We hear this all the time, right? So if you don't want people to be worried about the transparency, it's the same way that people argue for trials being, having cameras in the courtroom. Same thing. You don't want anyone to think there's anything fishy going on. Yeah, I don't know. I hate it that I don't know these names. Emma Bailey and I don't know their names. I'm sorry. Maybe someone else in the chat would. Well, again, let me just clarify this again, Triple R YP. They're arguing. They're not agreeing. The defense wants the hearings open and the prosecution wants them closed. So they're disagreeing. Maybe what you mean is that they've swapped arguments. That would make sense. Like the prosecution is arguing what the defense usually does. Maybe that's what you mean, but they're not agreeing at all. They're disagreeing. So
4-424. So the state followed course. We have filed all of our responses under seal and then filed this motion to close the hearing to discuss those previously sealed details. Now the defense is taking a contradictory position and asking the court to ignore all the previous filings. And this is just entirely inconsistent. To be clear, the state has nothing to hide. However, it's crucial that we protect.
The state has nothing to hide. It's one of those things where it's like when we were talking about Alec Murdaugh, for example, right, guys? Exactly. Tennis girl, yes. But dude, when she said that, and again, I hadn't listened to all this until now because there was all this other stuff going on, but this just reminds me so much of Alex Murdaugh, where it's like, had they not said this, like had he, okay, let me take it back to Alex. Had he not said XYZ, I wouldn't have thought of it. The fact that she just, let me rewind that. That's nuts to me. Hold on.
All the previous filings, and this is just entirely inconsistent. To be clear, the state has nothing to hide.
Like the fact that you're saying that though, reminds me of times when people, I don't know. This isn't good. That does not give me a good feeling. Now I don't know why. It is clearly there's some reason, right?
However, it's crucial that we protect, as we have been trying, the integrity of this case, and that we protect.
So Need Some Z's is saying that they're recommending. So I appreciate that recommendation. Personally, I stay away from speculation. And I try to stick more to like the way that I'm handling this. So okay, like Murdoch for me is the trial's over, right? And there's still things we don't have answers for. However, I still wouldn't say that I would go off on wild speculations, because I feel like I if nothing else, I can say I'm pretty informed about that case and everything about it. And so any conclusions that I draw are based on the evidence. But that's why I'm sticking to covering the court filings and the hearings, like with this. So, and especially because there's court filings like every fucking day. But I know there's probably a lot of people speculating about stuff, and that's just not my personal, like, what's the right way to say it, philosophy, you know? Like I really, I hope to, what's the right way to say this? I hope to bring to you guys, like, at least in terms of this one, like where it's going to be mostly the documents, like, I hope to bring to you guys like these documents and break down sort of like how to understand them, and that, like, for example, like any information that we need, and all of, like, okay, how can I better explain this? I'm trying to think. So like this, hopefully I'm not able to say this very well right now. Hopefully I will show you what my intentions are, since I can't say it. But through going through the legal filings, both in this case and like with Gloria Satterfield, I hope you guys will see that everything that we could want and more is in the legal filings and in the trial. But if it's before trial, right? We don't have a trial yet, but we don't need, you know what I mean? Like sticking, it's just my own personal thing. Like I really appreciate sticking to the evidence and staying fact-based. And I think it can be dangerous to speculate, because then it's like the Wild West, right? There's no rules. It's like anybody can say anything. And then you get misinformation. And I have a very strong allergic reaction to misinformation. So yeah, hopefully that kind of makes sense. I mean, I 100% agree they should all be open to the public. That's true. Tennis Girl 101, thank you for that. That is true. Yes, Pryor did want cameras. I'm not sure that the state didn't want cameras, but I do know Pryor did want cameras, and I agree. That's 100% correct. Yeah. And I don't know why they didn't fight for the house to stay up. I don't. I mean, I think for me, any idea that the prosecution and the defense are working together is beyond too much. We've well gone beyond a stretch there for me, because jail for all of them would happen. And not only that, but why? I can't even use my imagination to try to explain that, because it's kind of just too out there. I don't understand how that could even be the case. But are you saying, is that not Delphi, as in the prosecution and the defense are working together? If that's the case, then I haven't heard that. It seems like they hate each other, in my opinion. So Need Some Z says, I totally understand not wanting to cover speculation. I will say the person I mentioned does show legal docs. Okay, well, that's good. Gotcha. Well, that's good. I appreciate that. Yeah. So I mean, and the other thing for me though, is that I don't know. I appreciate what you're saying. I don't know that I feel like it's appropriate for me to want to bring in like victims' parents and stuff, or friends or family. You know what I mean? Like I can't, you know, they're not, this has nothing, in my opinion, to do with them. I can't fathom that it would, apart from the fact that they've lost their loved ones. And that's not, you know, I'm not going to be talking about them unless they testify at trial or something. But, so I don't quite know. I think it's a stretch. We don't have any evidence that the prosecution and the defense in this case are working together on behalf of, I don't even know, on behalf of Bryan Kohberger. I don't even know I don't even know how to answer a question because I don't even understand how the motivation would be there in the first place. If maybe you guys can help me out as to why they would even work together. I can't say that people do or don't. I just don't even understand why it would happen. And there's no evidence of that either. But let's just get back to the hearing and see what else happens.
Ultimately, the right to a fair trial. So let's look at the factors. Balancing a public's right to an open hearing and the party's right to a fair trial. Let's go to the factors laid out by Rule 32 and Idaho Code 74-124. And when we do that, for a defense's fourth motion to compel, Item 1, Subpart A, discusses federal grand jury materials. Those are exempt from disclosure by federal law, as well as Idaho Code.
And what I will say too, I've read every filing, not every filing, almost every filing as it's happened in this case, and I've watched every hearing. What I will say is these two parties argue over everything. So at the very least, what I can say is this, regardless of whatever, if there's anything, whatever, funny business, I don't know. What I can say is this, there is no agreeing between these two parties. They argue over everything. So that's what I can say going from the legal filings and from the hearings. Now, having said that, are they raising their voices? No, but it's Idaho. We don't hear anything like that in Daybell either, right? Or in Lori's trial. They're very mild-mannered. From all the experience we have in Idaho trials, it's a more quiet, mild-mannered, less emotional, court. So
74-104 subsection 2. What they specify as subparts B through N, all of those items discuss evidence related to this investigation, of which disclosure would 1, interfere with enforcement proceedings pursuant to 74-124 subsection A, deprive the defendant a right to a fair trial and the state, subject to 74-124 subsection B and Rule 32 subsection E. And it would disclose investigative techniques or procedures which are exempt pursuant to 74-124 subsection E. For defense's fifth motion to compel, Item 1, subparts A through J, all deal with the investigation. All would be exempt pursuant to the same authority just cited. Subparts K through M deal with the names of private citizens who were interviewed, and disclosure would constitute an unwarranted invasion of personal privacy, subject to 74-104 subsection C. It could contain intimate facts or statements of which would be highly objectionable to a reasonable person, exempt under Rule 32 I-2A, or invoke traditional legal concepts in the law of the right to a fair trial, invasion of privacy, under Rule 32 subsection 3. Subpart N through O is exempt under interfering with enforcement proceeding, depriving the defendant.
So let me just clarify something real quick. So I'd be saying that I thought openly asking questions was okay. So that's all I was trying to do. I 100%, yes. But a question like this that says, wait, you're saying governments don't collude. That's out of my depth because we're talking about this case specifically. We're talking about this case in Idaho between these two parties. I'm not making any type of political statement. I don't follow politics in my life. I don't give a shit. I'm not, that is a very broad type of question that I can't answer and wouldn't know how to answer and is not relevant to what we're covering here. So that's not what that's not part of this discussion. You know what I mean? What we're talking about is these two parties and what's going on here. And, again, all that I see from these two parties is that they actually disagree on everything. from the hearings and the court documents. So hopefully that makes sense. I always encourage asking questions, but it's sort of like someone asking me, what is the meaning of life, right? I appreciate people. Feel free to ask the question. I love asking that you ask the question. If you ask me, what is the meaning of life? I don't know that I could answer that though, if that makes sense. Hopefully that makes sense.
To a fair trial, as well as disclosing investigative techniques or procedures.
I don't know everything.
Item 2, subpart A, names a private business and is exempt under the previously cited authority.
Abby.
Item 2, subpart B through L, deals with the investigation. Again, exempt under 74-124A, subsection B and E, as well as Rule 32, subsection E. Item 3 names multiple private businesses. It's also exempt under the same subsection, 74-124A, B, E, C, as well as Rule 32-12A and 3. Subpart I deals with the investigation, exempt under those same authorities. Subpart J involves a private citizen.
Do you know which court document that's from with the coroner? Because I'm sure, I could even pull that up. Like on the stream, I could pull that up actually, if you know what document that's from.
Exempt under those same authorities. Subpart K through B deals with the investigation and is exempt under those same authorities. Item 4 deals with IGG information, which has been sealed.
I'm just saying I have not seen any evidence personally in this case that there's any collusion happening. That's what I'm saying, I guess.
And is under a protective order from the court protecting its disclosure. If the court decides to open this hearing to the public, the state defense will be discussing evidence without any context. This will undoubtedly fuel speculation, lead to assumptions, and false narratives. The evidence discussed may not even be offered, and most of it likely will not be offered by either party at trial because it's either not relevant or material. The public will not have any means or context to be able to differentiate.
No, and what I will say too is here's my thought. The fact that what I'm hearing out of her mouth right now is usually what we hear from the defense. Here's the difference in my opinion, just in my personal opinion. It would be weird if they said it, the prosecution is saying what they're saying now, and then the defense says the same thing. They're all agreeing. That would be weird because the parties never agree in court, right? Then that would be weird. But why this is weird is because the prosecution is saying it and not the defense. But what is not weird is that they're disagreeing. It's just like they've just, the prosecution is saying is asking for what usually we hear from the defense, but they're still arguing, so that's normal in my opinion. But the reason that I'm pointing it out is because it's what's happening in the hearing, literally with the argument, right? And what we read it even in the filings the other day. We saw it in the court filings. But also, I think it's important for us to understand that if we complain about, and I'm including all of us, right? I want it to be open. We've already said, I think it should be open. If it's frustrating or we complain about one party asking for something to be closed, we should be complaining about it for the other party because that's only fair, right? And that's, I think that's my takeaway.
That. It is necessary to mitigate this by closing the hearing in order to preserve the right to a fair trial for both parties. The defendant does have a right to a public trial, but that does not mean the right to try this case in media. Let
me rewind that needs some Z's because I was probably gathering my thoughts for the last statement I just said. Let me rewind that about the private things. Don't what you call it. Don't let your mind
not be offered by either party at trial because it's either not relevant or material. The public will not have any means or context to be able to differentiate that. It is necessary to mitigate this by closing the hearing in order to preserve the right to a fair trial for both parties. The defendant does have a right to a public trial, but that does not mean the right to try this case in media. The defendant will get his day in court and the public will have a right to see what evidence the state has. But that should be evidence that is admissible pursuant to the Idaho Rules of Evidence. Now is not the time for that. We ask the court to grant the state's motion to close the hearing regarding the defendant's fourth and fifth motion to compel discovery. Lastly, I ask you to issue a scheduling order for the parties to disclose witnesses, exhibits, expert reports, or any other evidence they plan on relying on for those hearings. Prior to the hearing, the state proposed May 3rd, and then a response to those by May 10th. And the state takes no issue with this being a dual deadline. Thank you.
Okay, thank you. May 3rd might be a little quick.
Well, Your Honor.
Mark?
So need some Z's. Let me just show you this real quick. We've gotten fancy over here. We gotten fancy. All right. So this is why I was asking, because I can pull up literally any court document from on the stream from the very first one. And we went through this the other day because it's hilarious how long we can scroll here. There's 50 trillion things. These are all the filings starting with December 29th. So anything that you're referring to in terms of a document regarding the coroner or anything else for that matter, if you know even just when it was from, we could read it on stream, and it's going to keep going and going and going. And actually, you know what? Not a bad idea, because there might be something else new since the last time I refreshed this. Let's see. Oh wait, we went too far. We're on Chad. Okay. Nope, nothing new. We already covered this one the other day. So yeah. So just so you know, I refresh this on a regular basis because there's always filings coming out. So.
Right. But our motion was filed over a week ago.
I know, right?
So yeah, everyone's been on notice of what the state was asking
I
for.
agree. They should hand it over.
Thank you.
They should hand it over. Yeah, they should hand it
Taylor?
over. Sure.
Thank you, Judge.
They should hand it over.
Our discovery requests have been filed for months, and they've gone unanswered too. So if we want to talk about being on notice for something, we can talk about that.
Can I just add, because I've read through all of the fourth and fifth, and it's, I mean, some of the information it seems anyway. I mean, it's hard to know, okay, but it seems like the state has provided and has responded to some of those requests, and some they're still waiting to get that information. So that's the impression I had. I don't know if you disagree with that or not.
I would say the court is maybe in part right, but there's a lot of other parts to those fourth and fifth, and the court's referring to our motions to compel, not discovery requests themselves, but they do reference a number of discovery requests that have been going out. And we can talk specifically about each of those items.
I prefer not to.
And which is fine. I'm prepared to talk about why this needs to not be a closed proceeding today. But I don't agree that the state is completely responsive here. So I think the court can read and see that they say, we'll get it when you get it. I think the court can read and see when they say, we're not going to offer it, so we're not going to get it. I think the court can read all of those things, and we'll talk in depth on the 14th about what they mean and some of the ins and outs that go into play with those. But there's a lot more than just meets the eye. With regard to the hearing on the 14th, the state directs the court to look at Idaho Court Administrative Rule 32 and Idaho Code Title 74. And those really talk about documents that the court can seal. And both really are in, if you look at them, they
Uh-oh. What happened? I don't know what happened. I think hold on. Can you guys hear me? I don't know what happened. Maybe because of my screen sharing. Hold on. Let me just see.
both really are in, if you look at them, They are to talk about openness of the court and public's right to have information and what things the court can shield from the public and what the public has a right to know. And when we're talking about documents, it's been brought up that we've filed a lot of documents under seal. We have. Those are documents that end up in the public record that thousands of people can read. And we file those under seal for expediency in saying this is exactly what we want from discovery. If the court looks at the documents, and the court can and probably has through the year and a half this case has been pending, there are a lot of names and specific bits of information in there. And so for expediency, we filed those under seal and for the reasons outlined in Idaho Court Administrative Rule 32. But what we're talking about now is a public hearing. When the state has decided to not give us information or to drag their feet on giving us information, we're talking about a public hearing where we have a right to be in the public eye, a public hearing. Bryan's the one with the right. It's his Sixth Amendment right to have a public hearing. When the state wants to close a hearing, or any party, and the other party objects, which we do, the court is guided by case law in the state of Idaho and the backdrop of his Sixth Amendment right to a public trial in the United States Constitution and Article 1, Section 13 in the Idaho Constitution. So in the backdrop of that, the court is guided by case law. And the specific case, there's a couple of Idaho cases, State versus Kimbley and State versus Olivine, and they
the defense right now, so they're still arguing over if these upcoming hearings should be open or closed. So we've had a good bit of discussion about what's going on here, because what we've got is a reversal from what we typically see, where we have the state who made these motions, as you probably know from last time, the last live stream, but the state has made these motions for the upcoming hearings to be closed to the public, and the defense objected. And so this hearing is them arguing over that. So we've had a bit of discussion about why this might be happening. And, I was reminding everybody that by default, they should be open to the public, so that you have to actually go out of your way to try to, make it closed or whatever. But that they're just arguing over what should happen, right, with these upcoming hearings. And of course they're going to be talking about the IGG, it sounds like, and maybe I think at this point they've already agreed that the one regarding the alibi and the cell phone shit is going to be open. I think at this point it's really they're arguing over the IGG, which makes sense because they
refer the court to Waller versus Georgia, and that is at 467 U.S. 39. And that puts forth the test that the court should look at when determining whether to close a hearing or leave it open and let it be a public hearing. And that the court has to find that there's an overriding interest that the hearing should be closed. In this case, in this hearing, that's not what's happening. The court would look at Bryan's rights here to a fair trial and balance that against the state's request to close the hearing. And we would want the court to consider that this isn't the state trying to protect Bryan's interests at all. He has the right to the public hearing. This is the state trying to protect what the state's doing. And the court should look back through the history of this case. This is our fourth and fifth motion to compel. Motions to compel 1, 2, and 3 were public. They were right out in the open with the public. The specific discovery requests were also sealed. So this has been a pattern to do things in the public. And now this one needs to be sealed. The court has to ask itself why. And the court should ask itself, what is the state trying to hide here? The things
I think that Chad and Lori were indicted by a grand jury. I could be wrong, but I believe they were indicted by a grand jury. Wifey, if you're listening, you can ask questions. Like I said, I'm worried that Wifey's worried that she can't be asking questions. And I like hopefully she heard me say that I encourage everyone to ask questions, but that I'm just giving you guys a disclaimer. I don't have all the answers. So but you can still ask the questions. I just want to be clear on that. I just don't have all the answers, but I appreciate the questions regardless, right? Like I've said before, y'all know that's important to me. Asking questions, it's about asking the question, even if we don't have the answer, right?
That we're seeking in these motions to compel are things that are outlined in the probable cause affidavit that has been public for a year and a half now, that has been offered to be shared far and wide. We're looking for things like videos that the state said they collected so that we don't look at things in a little vacuum. The state tells you not to take it out of context, but that's what they're doing. When they want us to do this in private and not let the state know about the full scope of the videos that are out there that they haven't given us, that is the state keeping things in a vacuum to control the public narrative. And that—
Wait, videos of what? I hadn't heard that until now. Again, like this hearing hasn't really been covered because it was during all the other trials today. But videos? Hold on, let me rewind that real quick. Videos.
Private and not let the state know about the full scope of the videos that are out there that they haven't given us. That is the state keeping things in a vacuum to control the public narrative. And that violates Mr. Kohberger's rights. That's what we want to prevent. This needs to be out in the open. Your Honor, I'll give you a couple of examples. The state filed last June its motion for protective order of the IGG materials. That motion was filed in—
I mean, my personal opinion is like, regardless of what any prosecution in any state is or isn't doing, I just think everything should be transparent and open. I just think I mean, obviously if they're doing something fishy, obviously they're not going to want it to be open, right? But I think for that reason, it should be open. All right. And that's the thing. Again, it's, what do they all say in the legal community? You know, it's that you don't want they do everything in the legal community to avoid the perception of impropriety. Just like, think about Becky Hill, right? That's the reason why they say it's such a big deal if you say anything to the jury, because even if you're saying something that's harmless, it can give the perception of impropriety. It's such a big deal when it comes to this stuff. And so even if there's nothing shady going on, whatever, it's so important to keep things open to the public for that reason, because what happens if it's not? People speculate. Fuck yeah, super planner girl. She is doing a darn good job. If I'm ever in a bind, I either want her as my attorney. I mean, not that well, maybe for having a knife, right? Accidentally. Her or Mr. Yannetti or Mark Eiglar. You guys will hopefully come to know pretty soon if we cover him, his opening statements. But yeah, I'm trying to remember. I mean, there's been so many hearings. I just don't remember videos coming up in a long time. So, yeah, maybe the car. It could be the car. It could be the car. But I feel like they turned that over already. We'll see what Judge says, because I feel like they did turn the videos. I don't know. It's interesting. But yeah, I mean, she's doing a fucking phenomenal job.
needs to be out in the open. Your Honor, I'll give you a couple of examples. The state filed last June its motion for protective order of the IGG materials. That motion was filed in public. It's on the public record. People can print that and read that and do all day long. And that had information that was negative about Mr. Kohberger.
I just have to say, I couldn't agree more with you, super planner girl. I hear that all the time from my my role models, or maybe not, I don't know if role models is the right word, but the people who I love on LawTube. The system needs to work for the worst of us so it can work for the best of us. 100%. Absolutely fucking 100%. Yep. And that's why I think it's so important to try to be objective and review these things from as best we can from an objective and an unbiased standpoint. And that's why, like I'm saying, I think that just as how we might get frustrated if the defense wants something closed, you know, it's frustrating for me if the prosecution wants something closed. So that's sort of my my thing.
So that's out there in the public. But that order was to protect information, the IgG information, that they say details how the state got to Bryan in the first place. That's been sealed. That's fine. We respect that. But you have to question, why can we not talk about the things they're not giving us? Why can we not talk about the cell phone information, the tower information, the drive test information in a public arena? Why should Bryan have to have his case, when he's asking for this information, be done in a little vacuum where the state says what the public can hear and what the public can't hear? Another example of this, Your Honor, is with the video tape that they've relied a lot on in their probable cause affidavit that we've received different parts of. Part of the hearing on the 14th is to talk about the different parts of that video that we've received and how we need the whole context. This is the video that they say places this car near the residence. We've received little tiny pieces of that. And we think Bryan's right to a fair trial means the public needs to know that they've withheld the audio from a great portion of that, and that it starts a long time before the little clip that we've received. To do this in a vacuum, Judge, when documents are filed under seal, that's fine. Those are documents, but this hearing needs to be in the public eye.
No, don't do the
documents. For the court to allow the prosecutor to say, we need to keep this all private for a fair trial, really ignores the public nature of this case. It really ignores.
I mean, that's what's so interesting, right? Because the prosecution's like, we need to keep this private for a fair trial. And the defense is like, we need to keep this open for a fair trial. I mean, do you see how, like, this is my point. This is why, I guess, if anything, the idea that they're working together, I can't get behind, because they disagree on literally everything. They're saying the exact opposite. They're saying things that can't both be true, right? One side saying it needs to be closed to be fair, and the other side saying it needs to be open to be fair. Like, you couldn't get any more opposites than that, right? Does that make sense to y'all?
Ignores the fact that Bryan has been essentially convicted in the media. You don't have to read but a few articles to see how negative they are about him. He has a right to have this information withheld, brought out in public, so that people can see it's not this neat little package. So people can start to wonder if Bryan's innocent.
Don't be sorry.
Bryan is innocent.
Don't be sorry.
And he has an absolute Sixth Amendment right.
You know, it's just, it's my fault if I couldn't explain things in a way that made more sense. But I think that statement right there, hopefully that made it pretty clear, because of their own languaging. You know what I mean? Where they're because you hear it from them. But yeah, I think what she's referring to, it seems like, just context clues here, it seems like what she's referring to is the car around the time, right? Like, I'm thinking of like the footage of the car around 4 a.m., what have you, in the neighborhood, that type of thing. And we did miss Wifey. We did. And hopefully, Wifey, I was talking to you. I don't know if you were still here listening, but I was talking to you, and I was saying that, like, I love the questions. Keep asking the questions, you guys, but I don't know everything. I was saying, like, I love if people ask something like, what's the meaning of life? I love that you asked the question, but it doesn't mean I can answer it. But hopefully, I don't know, just, yeah. So it's all good. I appreciate everybody that's being here, and we're all contributing. We're all trying to figure it out, right? Because it's tough. It's tough. And it doesn't make sense. And this is, I'll just emphasize again, like we said in Murdoch, right? Sometimes, I'm going to quote my philosophy professor one more time. I know you guys, some of y'all have heard this before, but this is a different case. So, but when I was in college and I was considering double majoring in philosophy, but I took some philosophy classes, and I had this great professor, Dr. Rubel, shout out to Dr. Rubel. And he said that, somebody was saying something like, we were talking about whatever, probably something like the meaning of life, right? If I had to guess. And somebody in the class was saying something like, like, I feel like, I'm more confused or whatever. And he said, philosophy is not about getting answers. It's about asking more questions. He says, if you're asking more questions, you're doing it right. Like, that's the point. The point is to ask the questions. And I just really think about that all the time in my life. Well, not all the time, not nearly as much as I should, but I've been thinking about it a lot in regards to the cases, which is great. Because, my nature is to try to know everything. So it's checking my own, it's me also trying to work through my own personality flaws. You know what I mean? Of wanting to know everything. It's not possible. So it's helpful for me to remind myself that that's not possible. But also the nature of asking the question is just so important. So that's why I always encourage it. And that's exactly what we're asking these questions about, because we don't know. We have no idea what's going on, but it's okay. We're all here together, supporting each other. So, and yeah, I agree with you, tennis girl. I hope so too, because I think it needs to be open. I do. And that's the thing. And the fact that the state even said, we're not trying to hide anything. It's like, oh boy, it's not looking, it's just not a good look.
To have his hearings in public. We think if the court allows the state to shield the information and how they got their information and what they don't want us to have from the public, they're using his Sixth Amendment rights to hide behind. And that's just not what the court should allow. We strongly object to these kinds of things being closed.
She's right. She is right. They're using his Sixth Amendment right as an excuse to have it closed. She's fucking right about that.
Ms. Taylor.
Very astute.
I don't know where did it stop though. I mean, if we start pulling out all the potential evidence before the trial, then does the state get to respond to that? And that's where does it start? I mean, or stop? It just is a roll of that. Yeah. And so either side, okay.
I love you, wifey.
That it sends to the public that it is not, you don't get the context. They don't have the context, the public. You have the context. You want more context. I get that. But it's really difficult to just open that up and talk about particular issues in the case without talking about the entirety of the case. And that's what trials are for. I mean, I totally understand that Mr. Kohberger has a constitutional right to a public trial, but having a hearing is not a trial. That's something different. And so that's why,
That's interesting. Did you guys hear that? That's an interesting distinction. He's saying, and hearing is not a trial. That's a good point, because both sides right now are arguing over Bryan's right to a fair trial. Super Planner Girl, very astute here. Yeah, right. He's not even saying anything, right? He's just sitting there. But what a great point from Judge, which he's saying they're arguing over his right to a fair trial. He's like, this isn't a trial yet. This is a hearing.
Well, the balancing comes to, if you want to answer that.
I do, Judge. The Waller versus Georgia case is in the context of a motion to suppress. If the court starts closing hearings now, when the court hasn't closed the other motions to compel, what's the court going to do when it comes time for a motion to suppress? Those are coming. Many of them are coming.
He's like,
we want the hearings in public. The state has dropped bits of information with different filings they've made all throughout the way. This can't be done in private. It just can't.
I agree.
I say both sides have said in their motions or their briefs that they disclosed, certain things.
Yes, do it, Judge.
And
yes,
it's a change. See that because both sides have agreed to seal a lot of these issues of evidence in the discovery. And so all of a sudden it just does feel like it's moving in a different direction. But I understand what you said. It's like, this isn't about discovery. This is about the hearing.
Your Honor, those are discovery documents, and there are things in there that the state's chosen to respond to. The state selected which things that we have to have a hearing about. And these are about things that are in the state's possession or control that we want them to give us, and we're asking you to order them to give us these items so that we can do our work, so we can complete our investigation. It's not any different at all. Sealing the documents, I think that
Super Planner Girl's asking my opinion on Judge. I was about to pause it anyway to make a joke because she's talking about discovery, and I was going to say something like Judge is trying to discover the solution to all their problems. I fucking love Judge. That's my personal opinion. I love him. I understand that some people think he's taking a long time. You know what? Like, I don't. Him taking a week or a few days or 2 weeks to make a decision on a motion is not the reason this trial is pushed out so far. It's just not. So while I can understand if that's maybe, I mean, I've heard some people complain about that, and I don't know if that's what you're thinking of when people have mixed feelings, but I've heard that from some people. But I think that, again, it might just be that they're kind of conflating that the fact that this trial is potentially going to happen in 2025. That's not because of Judge taking time to decide on stuff. And because the trial's not going to happen until that, in other words, I actually really appreciate his measured approach. And my favorite thing about him is I love his mindset because he really approaches everything from a philosophical kind of standpoint. We've heard him do this before in other hearings where he actually will confuse the fuck out of people that are commenting on it because they're like thinking he's going to do this or do that or whatever. And I'm like, I feel you, Judge. I see the way his mind works. He just wants to understand the nature of the thing. It doesn't mean he's going to, people are trying to think, oh, he's going to rule this way or that way. And I'm like, no, he's just asking the questions. See, that's why I like him. But he's not a judge. I love a lot of judges, right? And you've got some judges that, like Judge Newman, very decisive. There was no fucking around, he knew exactly he's going to, it is what it is, done. And then I equally love Judge, who's like, really wants to fully understand and contemplate it. And it's just a different, and I love it all. I really love, but I think he's very fair. I think he's very measured. He also has a really great sense of humor that will take you by surprise sometimes and catch you off guard, but it just makes it even more, like Judge Boyce made a joke today in the Daybell trial, and I was like, what? I think it was the first time I'd heard him say anything funny ever, and I listened to all of Lori Vallow's trial, but he made some sort of joke. I don't even remember what it was. I don't even know that it was like super whatever. It was just like some sort of comment or something funny, and I was like, holy shit, Judge Boyce. But I think that's like an Idaho thing maybe. But anyway, every now and again, he'll make little jokes. I don't know. I adore him. I really do. So... for sure. That's 100% true.
It needs to continue to happen. That there are a lot of names in those documents and requests for follow-up. We don't have to do that. I do think those are fine. And I think they're different because they're documents that are going to sit in the public record they're different than having a hearing of things that the parties haven't been able to resolve on their own that the court needs to resolve. Public has a right to see how its business is carried out. My interest is Bryan's right. But I would ask the court to remember the history. We've had motions to compel 1, 2, and 3 in the public eye. All of a sudden we get to 4 and 5, and we understand the subpart of 5 that has to be in a sealed proceeding. That is going to directly deal with documents the court has ordered be protected. That's completely different than when the state won't give us bits of information that's within their possession and control that we need to prepare our case. Your Honor, I would ask the court to consider, too, how much pressure there is to get to trial. We've heard the state say they'd be ready by this summer. We've heard the state say they're going to be ready by March of 2025. We've heard them say that they've given us 95% of discovery. We've heard them say they've given us all of the discovery, and those things just aren't true. They're just not true. You can see from the list of things we don't have, there's no way we have 95% of it. So when there's all of that in the public eye and the pressure of let's get to trial, I think the public has a right to see, and Bryan has a right for the public to see that we're trying the best that we can. The court offered to do what it could.
The way that she stands up for Bryan, dude, I was thinking about this. Because I understand, I get it. Like, it's hard, right? It's hard to imagine how even if you really are all for justice, I understand when sometimes if you think about it, you're like, God, how, but at the end of the day, how could somebody get around the person they're defending? Take any, serial killer or whatever, right? It's like, I was thinking about this because, I, you've got people who are defense attorneys who understand the importance of their job and all that, right? This woman is on a different level. She is the epitome. Like a great example is how what everyone calls the guilt phase, which is if you're guilty or not guilty. So, okay, let me just back up. In a death penalty trial where there's two phases, right? The first phase is normally called the guilt phase. She calls it the innocence phase. And then same thing as what's normally called the sentencing phase. She calls it the mitigation phase. She doesn't just believe in the concept of it or whatever. In my mind, it's like, I think myself, definitely, I'm not going to speak for anybody else, but I'm not good enough to be able to do, like, in other words, it takes someone who, it's like a Mother Teresa in my mind, right? The type of person who can, it speaks to their goodness, in my opinion, if that makes any type of sense, and not their badness. But anyway, I was just going to say, she is just, the way she genuinely gestures towards him, despite what we might think of him, right? Put that aside. I find it personally moving because think of how she must be as a person to be able to do that. She's like, in other words, in my mind, I'm like, she's a better person than I. She's a bigger person than I to be able to treat him with humanity. Does that make any sense to you guys? Like, using his name, she's treating, and you can just see it in her. Let me back it up just a sec so you can see like the way she gestures towards him is what I'm referring to, is like how it's to me, it's moving. You know what I mean?
For the public to see that we're trying the best that we can. The court offered to do what it could to speed this up, having hearings about things that
go back
public eye and the pressure of let's get to trial. I think the public has a right to see, and Bryan has a right for the public to see that we're trying.
It's like kindness. It's kindness. Yes, absolutely. Yeah, 100%. It's kindness. It's not just the concept, because we see great defense attorneys all the time who just, they're really good at their job and they believe in the concept of it, the importance of it, but they don't treat their client like they actually are innocent in a way, right? Until proven guilty. Yeah. And absolutely. Yep. I know. It's like it's her son or something. I mean, it really, it's, and just the thought of what it must take as a human being to be able to do that. It's like the type of thing, I don't even know how you ask that of somebody. You know what I mean? It's really, it blows my mind every time. And in a really good way. It's like, we don't ever see this. I don't know that I've ever seen this type of genuine care. And yeah, it's just, I find it's really, in my mind, it's really inspirational, actually. Because it's easy to love someone who didn't do anything wrong, right? It's easy to stand up for, I mean, not that I'm saying she loves him. You guys know what I mean. You know what I mean? But like, it's much harder. Again, like I said, it's a matter of goodness. Like, she's a better person than me. I don't know that I could be like that, but I wish I could, I think that's just a goal to strive for, just for me personally. You know what I mean? Like, in terms of, you mean how she's been treating him? I would imagine that being treated kindly like a human being would be a good thing for someone, especially who's young. I mean, this is just my personal opinion. I would love to ask that to Dr. Bricado. But for someone who's, if they did, like, let's take someone in this position, whether they did or not, you know what I mean? It's like being treated like this, I think could only be a good thing. Yeah. Paging Dr. Bricado is right. Yeah. Dr. Bricado. Yeah. I know there's stories. I'm trying to think. I'm blanking on it, but I know there's stories like this that in life of things where it's like some little act of kindness completely changed the course of someone's life. Maybe you guys can think of it, but I know there's tons of stories like that out there that are real that have happened. Where just one little thing, and then it changed everything for somebody. One little act of kindness or generosity, and somebody's life took a completely different turn. Happens all the time. You know what I mean? Absolutely. 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 Yeah, absolutely. And if there's any hope too for somebody, if they do get convicted and they're going to have LWOP, that's tough. That's tough. I think about this all the time too, because I just like, the best you can do is try to find something, right? And maybe the only thing you can do is try to think about how you can be a better person internally. It's not like you can actually do anything. If you're never leaving prison, you can't actually make a difference in other people's lives, but you can try to improve yourself. And I don't know, it's just, but hopefully you guys know what I mean? Like, and it does kind of seem like there is a difference. I don't know if you guys can pick, I mean, the camera's kind of far out, but like, it kind of does seem like I've noticed a difference in these hearings when the cameras do show him. I don't know. And also I feel like the people are less like the media and stuff. Like when I say the media, I'm talking about like law and crime, court TV. I feel like there's been less obsessing over him, like zooming in on his face and shit like that. Like, I don't know, or speculating. And the attention is really more on the attorneys, which is great. That's how it should be, I agree. Yeah, I agree. Yeah. And you guys know how I feel about Alex Murdaugh. But again, I would hope that if I ever say anything that sounds akin to dehumanizing, I would hope you guys call me out, because I don't want to do that. I don't mean to do that. But I don't ever want to dehumanize anybody, but you guys know how I feel about Alex. But hopefully I've not given anyone that impression for how I feel about him. So
the best that we can. The court offered to do what it could to speed this up. Having hearings about things that shouldn't be closed, that we object to being closed, takes time. There is no change in our habit or our practice filing documents under seal for things that meet Idaho Court Administrative Rule 32 subsection I, and us asking for a public hearing. There's nothing inconsistent about that, and that's the way we've carried out the case.
Thank you, Ms. Taylor. Response, Ms. Jennings?
Yes, Your Honor. Ms. Taylor's argued and multiple completely false narratives are the exact reason why this hearing should be closed. Yes, defense has a right to a public trial, but that is not the right to having all hearings open to the public. The court's right. There will be a day for this, and that is the trial.
I think
but we shouldn't be discussing all the evidence that we're going to.
I think she's making the wrong argument, because she's making the argument she prepared ahead of time, which doesn't take into account what judge just said, which is this isn't a trial, this is a hearing. And she's still talking about the trial.
Hear at trial prior to that. There's no right to try this case in the media. The case law that the defense relies upon has not extended this balancing test to these types of hearings. The hearings are about, or the cases are about trial. And yes, they extended it to a suppression hearing, which was so interrelated to the trial. Waller v. Georgia primarily stands for the proposition that any closure, it gives you this balancing test. We just went through the balancing test, and the state gave you the reasons for why this meets the test for closing the hearing. As far as being inconsistent, I would just note for the record, we have had one hearing regarding motions to compel.
I don't know who this girl is, but I want to hear.
However, at that hearing, This is your order. At the outset of the hearing, the parties informed the court they had reached agreements on all issues except request 160. We discussed one request and it had to do with training records. That is not what we're contemplating discussing at this hearing on the 14th. I've gone through the multiple issues and subparts, as well as the reasons why we cannot have this discussion in an open forum.
Thank you.
Want to respond to any on that, Ms. Taylor?
Well, Your Honor, we had the entire IGG state's motion for protective order and our objection to that in a public forum as well. That ends up resulting in us receiving documents that the court had a protective order on, and we can't even share with our investigators that come to court with us.
Now,
and
I'm going to say something real quick about the IGG. So I've waited on this a little bit the other day, but here's one thing I will say. And oh, by the way, yeah, so it's from needs and teas. Yeah, not only deserves, it's a constitutional right, you know, everyone. So, but yeah, so the IGG. So I was telling you all the story the other day about how I sent my DNA in to get the testing for my genetic, you know, ancestry for like because I wanted to find out how much Russian I have in my blood or whatever. But anyway, I'm saying that half jokingly because it became from my brother texting me and he was like, "Oh, I'm 20% Russian," and I was like, "What?" Anyway, so but I can speak from experience having used one of those databases. I think here's part of the issues that I see here. This is just what I think is part of the equation, right? I think part of the equation is that these websites, and I did mention this briefly the other day, but I'll say it again real quick. So these websites that do the IGG stuff where you can send your DNA in, they are not government regulated. They're private organizations. And it could be too, like when you mentioned needs and teas about private organizations and private people, this could be part of what that was about because these companies are private organizations, and the people who submit their DNA, like myself, and volunteer and say it's okay, you can use it for stuff like that, these are private individuals. So the whole thing is like when you do it, here's the thing, each website has their own way of asking for consent, and maybe some don't ask for consent. I don't know. The problem is it's not been legislated or regulated in any way as to the legality of it. Okay. And this is where it gets tricky because we're talking about these private companies. And in other words, and they've talked about this before, they've touched on this. And this is what's going to have to, like, eventually it's going to have to happen. They're going to have to figure this out because it is a problem because these are private companies, just like with anything else, right? If you want to buy whatever, a thing, right? I don't know. They're private businesses, whatever. And so, but the problem is that there's a line that's being overlapped here where people are having these services done and they're getting their DNA, blah, blah. And then they, you know, at least for some websites like the one I used, you have to actually jump through a lot of hoops to consent for them to use your DNA for the IgG stuff. Like you have to you have to try really hard. They don't make it where they can pull like you're automatically opted out. You have to go out of your way to be opted in. But some of the other ones may not be like that. I don't know. But either way, there is no required process of how that should be done. There's no regulation. But that's because there's a in this country, right? We have private businesses and then we have the government. And so that's part of it, right? And so it's a whole thing. And that's where I'm saying, like, it may not be that there's anything fishy. It's just that, like, this is a new territory that hasn't been just figured out yet in terms of what do we do with this? Because, you know, it's important to protect these businesses and they have their right to do their thing and blah, blah. But the people who, and similarly, the people who submit their DNA have the right to have their data and privacy protected as they agree to on their contract or whatever thing you sign. I think that where the problem is that there's no consistent method for each one. They all have different rules. And that I remember hearing them even mention that at one point. I think that's really what it comes down to, because you've got this whole list of names, for example, and some people may have consented and other maybe didn't consent, or the way it was consented was kind of not clear. Did they really understand what they were signing? And again, that's why the one I used, there was no ifs, ands, or buts around it. You knew what you were signing if you said it was okay, but they may not all be like that. And so that's where I'm saying, like, it may not be that there's anything fishy, but it's tough because of that. Because there is no streamlined method and there's no streamlined requirements. And I remember they had someone come in and talk about that. And, you know, it's something that I think is probably going to end up happening, but it could be a while. And so this is going to come up again. I will say that much. This is not, we will have this same problem again in other cases. This will come up again because this is now a part of all these different cases. And we're getting into this territory where people are, you know, again, there's more companies that offer these services. And so that just makes it even more challenging. It used to be there was like one or two, and now there's like there's many. So it just makes it harder because now they all have their own rules. And correct. That's right. Yes. I'm trying to remember. I watched that. It feels like a lifetime ago. I'm trying to remember. I remember that testimony. Here's what I do remember. That feels like a lifetime ago. Here's what I do remember from that testimony. I remember her testifying about this. And I remember thinking that she was testifying in a way that is what you would expect, which is to say this. It's that it's almost like semantics, right? Which is what we get all the time in law. Like, in other words, it was the type of thing where it couldn't rule something in or couldn't rule something out, in my opinion. Like, again, having gone through, like, to what she was testifying about, having gone through and filling all that shit out and seeing it firsthand, I remember hearing what she was saying, and I'm like thinking, if someone didn't know how this worked, I could see how they would interpret what she's saying. But having firsthand knowledge of it, it's like not the full whatever. I felt like it was like good testimony for that. What I mean by that is she's not lying, but she's also not saying anything explicitly, but you could construe it that way, if that makes any type of sense. It's what we see all the time with trials. Who is Paul Holes? Paul Holes? I don't know who that is.
Abided by that, and we understand that. But the entire hearing leading up to that was done in the public.
Oh, Bryan's dad didn't give permission. Fun fact for you guys. You get to learn things here, hopefully. Here's the deal. Anything that is in trash, when you take trash, think about LISC, right, guys? Anything that happened, that if you use a thing, whatever, anything that you put out as trash, it is now public property. He didn't have to give permission. He did not have to give permission. They got his DNA from the trash. Trash is public property. So, fun fact for y'all. Oh, your mom agreed with your wife. Okay. Oh, he correct. Okay, gotcha. Yeah. Okay. I remember Barbara Ray Venter was involved in that, but I don't remember Paul Holes. But yeah. So meanwhile, Abby's dealing with dog pee on the bed. But right, permission from the DNA place. Yeah. But right, okay. But Bryan's dad doesn't have to give permission with any DNA place because that's because the law enforcement can collect it legally. It's public property if it's trash. Yeah, I know all about the Golden State. In fact, I've got a book on it, but I just don't remember Paul Holes. But yeah, the only people who need to have consented is if they submitted their DNA themselves, mailing it in, like the way I did to get my ancestry stuff. So if you're a private person and you submit your DNA, you mail it to the business, that's different. But anything that's in the trash is public property. It's fair game. Anyone can do anything with it.
In that particular hearing, they talked a lot about DNA results on a knife sheet that I'm sure benefited the state to have that in the public eye. What we're going to talk about on the 14th, Judge, I don't have to name any private citizen names, I can talk about records that exist and why we should have them without naming.
So Super Planner Girl, I don't know if he was on file or not, but he wouldn't have to be. The law enforcement collected his DNA from the trash because it's public property. They're allowed to do that, and then that they send it in, right? Not my understanding is then they send that in to one of these places, and then they do their thing just like they would do if someone like me sent my DNA in, and they do the family tree shit. That's my understanding. But because it came from the trash, he didn't have to consent. That's my understanding. Thank you, Abby. What's your first favorite book, out of curiosity? They linked him to the crime scene because of the knife sheath, the DNA on the knife sheath. And they did a buccal swab on his mouth from his own DNA and tested it directly and compared it to the knife sheath. They only used the familial DNA to do a probable cause affidavit, not to make like an arrest or whatever. There was like 2 levels of that. And that's why they're saying the familial DNA, the IgG stuff, is not even going to be used in trial. It's not going to be used in trial at all from either side.
Naming private citizen names. I can talk about the videos that they've not given us. They're not about the business. They're about videos that were collected.
Like they used the familial DNA to like narrow it down to him, but then what they arrested him with and stuff is like be based on the knife sheath, which they matched to his actual DNA, if that makes sense. And that's what will be used
by the police. I can talk about those in the context of the police reports. And by the way, those are all things that are talked about in the probable cause affidavit. And I can talk a ton.
Speaking of the PCA, that's hilarious. I said it and then she said
about the cell phone information, the cell tower information, and the things that they have not given us, the drive test information, the verification of stuff.
That's the thing. I don't want to talk about those particularly. And I guess I'm reminded, okay, in your comment about the IDG, because once again, I'm in this position where I have to make decisions blindly to some degree, and that's what the case with the IgG. I mean, I had to go through all of that information, and then I provided most of the information to you, okay, to the defense, so that you could evaluate that. I feel that the same way about there's a lot of stuff, okay, that you're arguing about and the state is arguing about.
You guys,
and
dude, I'm going to quote Judge right now. There's a lot of stuff, okay, that you're arguing about and that the state is arguing about. I wish Wifey was here to hear that. I mean, that from the mouth of Judge, nothing has truer has ever been said.
I think it's complicated to just open that up. I think that, maybe we could go through a closed hearing and then open up what you feel needs to be opened up. But I can't make that decision in the abstract. So that's my worry, because I went through all this last night again, and I thought, how do we really fairly deal with each one of those issues? There are a lot of issues.
I agree with you. There are a lot of issues. I would ask you to look at the probable cause affidavit and read the parts where they talk about relying on FBI agents and the CAST report and different cell tower data. Your Honor, that stuff's in the public eye. Why can't I talk about what they refuse to give me in the public eye?
Well, one of the things that we want to talk about today is I just got motions for subpoenas, duces taken to the FBI. I mean, it's really difficult to get information from the FBI. You know that. They know that.
Yeah.
I know that.
Yep.
We have we have to jump through a bunch of hoops to get particular information.
What he's saying here is, even me, I'm Judge. I have to send a subpoena, duces take them, in order to get this information, from the FBI. He's saying that it's just hard to do. So Need Some Z's is saying, think about the time it took to get those results back wasn't very long, was it? How could that be? I don't remember how much time it took. Do you have any thoughts on how that could be? Need Some Z's? Like, I mean, they have the ability to expedite things. I'm trying to remember the name of that one place in Georgia that's paving the way for this IgG stuff. But I remember that lady from there was talking about, God, what's it called? Maybe one of you guys remembers the name. It's fucking hell. She came on SDS, but part of what she's doing is, they're compiling a database that uses the data. It's compiling all of the ones from the different websites together in like one place or something. And you put it so that they can have it in like one database. And then by doing that, she gave all the details when she came on SDS a long time ago, but the percentage of like how quickly they can like find these matches is like a trillion fold or something like that, where it just speeds the whole process up and they can do it way quicker. So I don't know if that might be part of it. So remember, part of what's in that, as they've said in other trials, or not trials, sorry, hearings, is that there's names of individual people, family members or whatever. Like, let me give an example. Like how I submitted my DNA. It's like, if for all I know, my name could be in it, right? Anyone's name, your name, and well, maybe not your name, but anyone who's done this and submitted their, like, your name could be in it. And it's like, imagine, like, I'll use myself as an example, right? And so then I'm like watching the next hearing and they're reading the IgG shit or whatever, the discovery, and my name comes up and I'm like, the fuck, what? You know what I mean? Like, I'm not really like, some people might be, I don't know that I would react as badly as maybe some people, because some people really, are like all about protecting their privacy. And here I am using my real, like, I just don't give a shit. I mean, anyway, but I would still be like, how the hell did that happen? You know what I mean? Like, how am I related to this? But we know that's a part of it, because there's people, personal, regular people who are not involved in the case, whose names are a part of this IgG data. And so we know that is part of it. Offram, that's it. Thank you. Offram, that's it. Yes. Okay. It's Offram. Yep. Thank you, Super Planner Girl. That was going to drive me crazy. That's it. Yeah. Yeah. So, but they're doing IgG stuff. If anyone wants to look that up and pop it in the chat, they're doing some important shit with that IgG stuff for sure. They're on the cutting edge. And I remember they were talking about some case where they were like, if they get Offram involved, they're going to get a DNA match like in 2 weeks or something. I'm trying to remember. Again, this was a while ago, but they're Offram. That's it. Thank you. Yes, that's the correct spelling. I'll put that back up. Because the thing is, and that's why, and so the FBI, and part of it, because again, the FBI, for example, like with somebody like Bryan's dad, for example, right? They can get DNA from people's trash, right? So I think there's a whole thing about, feel free to share what you learned, but there's the whole thing about, protecting people's privacy when they didn't do anything wrong. They didn't commit a crime. And they're not in the criminal CODIS system, right? That's the thing too, and that's the other thing, is that they probably are also using they're probably using DNA from both the criminal, like, CODIS database, as well as, these private ones where there isn't any crime involved. So they just have to be careful about protecting people's information.
From the FBI.
Mention, remember, there's some people who may not know they're adopted, right? There's some people who are doing that for like paternity reasons. We have to remember there's all kinds of reasons that people do that they could find out something they didn't want to know. I mean, shit like that too.
The state's issue, although maybe it should have happened 6 months ago.
That's the state's issue.
I understand that. But that is one of the things that, we can maybe address that.
Let me just be clear. This IgG is not coming into trial. It's not coming into trial. they had already developed the information with the IgG prior to getting the test results back on the touch DNA. And I think they had his name, potentially the first way they got his name was because of the University of Washington guy looking at the videos or whatever and being like, hey, we have a student that has that car, right? That was how his name first came up, was because of, like, it was like a security guard or a cop at the University of Washington who went through and looked at the people who had white Elantras. That was the first way. That from I think what they've said is how they first came up with his name.
Today, too. I don't think,
Good night, Super Planner Girl.
thinking that you don't have an objection for me to sign the subpoenas.
No, Your Honor, I don't have an objection for the court to sign the subpoenas to try to get the information.
So I can sign that today.
You can sign that. You can sign that. Anything you need to sign to get us the things we want, please sign.
I'm with you. I'm trying to do that. And, from what I've seen, I mean, I think the state is trying to do that. I know that it's not satisfactory from your position, but there's a lot of issues in this case.
And Your Honor, that's really a lot of what we're going to talk about on the 14th, is the timing of these things,
right.
Not the full content of what we think these things might show. We don't know. We don't have them. They know.
Likewise.
So I think the timing is important. Your Honor knows how much pressure there is to get this case to trial, and Your Honor also is aware of all the things that we have to do. And when we make a request and months later, you're asked to sign the order so that maybe we can finally get that information, that timing part is important for the public to know.
Need some Z's. I don't even know how to answer your question. I don't even know how to answer any of that. Because it's so, I don't see how that's related to anything of anything that we have in this. It's like almost, I don't know if you're talking about a different case. I mean, Bryan is spelled with a Y, so I don't know. I mean, you're saying sheath. This is the only case I know with the sheath. I don't even know. If you, if you can refer back to some sort of evidence from what we have so far that refers to any of that, then maybe I can better answer a question like that.
No, that's not the content. I'm not going to talk about the content of that subpoena you just brought up. I don't need to talk about that at all. But I can talk about the delay in this and why there's a delay in us being ready for trial. That is fair game for the public, and that is something Bryan has an interest in having public. So I don't have to talk about that content. That's not the issue at all. But the things that are laid out in the probable cause affidavit that has been on the court's public website for 1.5 years now, it makes no sense that I can't ask for those things in the public when they're things that the state said they relied on. That just makes no sense. I have one more ask when we're done with this issue.
Okay, thank you. I mean, are you expecting to make a decision right now? Maybe not.
Well, Judge, you should just make the decision to have the hearing open. And if I start to talk about content, then maybe you can talk about it then. I don't agree any part of it should be closed. I don't agree any part of the hearing should be closed. And I think you should make the decision now. We're 2 weeks away from this hearing.
Oh, 2 weeks.
So what are you going to do?
Is that right? 14 days?
Decision?
We're less than 2 weeks. We're 12 days.
All right. Well, I kind of mentioned this a moment ago. I just feel like we need to get into the details, okay, of all these issues before I open it up. So I'm going to close that hearing. Now, that doesn't mean that after we sort out all of those issues and I have more understanding of why you are getting what you want or what you asked for, or whether or not there is something that you've asked for that doesn't exist, or that some of the materials are holding with the FBI, and that we need to get that. I mean, those are all really complicated processes, and I would feel much more comfortable when, again, I'm trying to protect a fair public trial and not have a maybe not intentional unfair hearing, okay, that goes out to the public. I think that's the balance for me. That I want to see what all the issues are, the arguments from both sides, so that I can make a more informed decision. So I'm going to close the hearing. At some point in that hearing, maybe we can open up part of it. But I need to dig in, and you all need to dig into exactly
Okay.
what
I think what he's saying here is that if I'm understanding him correctly, I think what he's saying here is that, and this kind of makes sense, right? That it's hard to rule on. There's going to be specific things. Okay, that I think what he's saying is there's going to be anything that could cause the hearing to where it should be closed, right? For example, let's say it's people's personal identities, for example, that he's not going to know because they're not discussing the actual contents, right? Because they can't until the actual hearing. I think what he's saying is like he's not going to be able to rule on if anything should be closed until it gets to that. And so the only way to even discuss it would be to close it to discuss it. So I think that's kind of what he's saying. Like it's going to be open. And then when they get to the point where there's something that could potentially be a reason to close it, they're going to have to close it so they can talk about what those things are without anyone hearing it, essentially, is what it sounds like he's saying. And then decide, and then to go from there, maybe.
is the problem with each one of these issues. All right. So let's talk about the schedule. Okay, the state asked for this, some disclosures of witnesses, expert witnesses, exhibits by May 3rd. I don't think that's particularly practical at this moment. I know that you had, and I'm not looking at it right now, you got another idea about that, Ms. Taylor?
Judge, I think I had May 7th.
Okay. That seems more practical. Okay, so I will put an order out, schedule order for providing. I don't know if the state really knows what you do until you see what they have. And you're shaking your head, yes.
Yes, sir.
And that means that maybe you don't have any witnesses, expert reports, or exhibits at this point because you don't know what to expect.
Right.
And this is related to the hearing on the 16th, right?
In the 14th, I'm not sure.
Okay. And there may be witnesses on the 14th too, as well.
Just to refresh y'all's memory, as it stands right now, the plan was for the hearing on the 14th to be open and the one on the 16th to be closed. However, it sounds like now the one on the 16th might be partially open, and then they're going to kind of see what comes up or whatever.
Yes, Your Honor.
Okay. All right. So let's make it May 7th for disclosing witnesses, expert reports, and exhibits. We'll see what the state has to do with that, and we'll have a response maybe May 10th. Is that sufficient?
Okay.
It's tight.
Well, that gives us 3 days to respond.
3 days. Yeah, that's right. Well, May 10th is I don't know when I'm going to read all this stuff too, because it's 14th. So if I don't have it by the 10th, then you're saying the 13th. I guess I can do that the night of the 13th. But also, the defense needs some space there too. And I don't think we want to push out that hearing. Can't do it by defense.
We have no idea what the defense plans on doing, and that only gives us 3 days to read, comprehend, and respond.
We'll deal with it. We'll deal with it the 13th then.
Yeah, I mean, we can try, and then if we
Okay.
need more time, we'll ask for more time.
It's just then on my end, you're looking at, I'm going to have really more, I'm going to need more time.
Your Honor, I don't expect reports. I expect to provide a witness list.
Okay,
I don't expect there to be reports.
exhibits.
There may be exhibits. I think there will be at least 2 or 3. I know some will be things that they've already given us in discovery, so they shouldn't be new and surprising.
Okay. I mean, it's hard to have these tight, timeframes because we also have other things to do. But Mr. Thompson?
Your Honor, it's completely unfair and unacceptable for us to get a list of witnesses with no idea what they're going to testify about. The names witnesses don't mean much of anything. And unfortunately, we're having a pattern in this case of last minute disclosures of witnesses and PowerPoints and all sorts of things.
He's
It
still mad about
frustrates
the
Your Honor's
PowerPoint.
ability to assess what's going on because it's brand new to you, just like it's brand new to us.
Mad from, like,
And I think that practice has to stop.
that's funny.
We need substantive
Let's judge each other.
disclosures. If they're offering experts, the rules of
Let's judge
discovery specify
Sorry, he's good. Santa's mad. What's Judge gonna say?
what you have to disclose regarding an expert, and that's not just a name. So what's being propounded by the defendant right now simply isn't within the rule. It's not appropriate. It's not fair to the court or to the state.
Okay. Well, I mean, you don't have to have witnesses or exhibits, but you can have a response to say, well, this isn't fair, or whatever you want to say. Otherwise, I just need to push out this hearing. I'm stuck.
I appreciate that, Judge, and
Santa, what happened?
I guess we've said it before. It is more important to do it right than to do it quickly if we have to have a trade-off here. And that includes fairness to everybody involved, including the court. And I would prefer that this not be kicked off, but we're realizing that we're 2 weeks, essentially 2 weeks or less away from these hearings, that apparently there are going to be a number of witnesses that nobody but the defendant knows who they're going to be and what they're going to try to say. And then we're expected to.
He's referring to the alibi again, I wonder. Hi, Candace. Happy to see you. Yeah, angry Santa. I know. His demeanor has completely changed since that. He seemed all nice and Santa-y. And then after that hearing with the jury expert dude, he is a different Santa.
React in court. That's just simply not the way to operate an effective, efficient, fair process.
Well, let's explore this. I mean, how many witnesses are you expecting to have?
Your Honor, I'm expecting to have 2 on the 16th.
Sorry, that's classic John Judge. He is John Judge. Sorry, that's classic Judge John Judge. Okay, that's classic Judge John Judge saying, "Let's explore this." That's the type of thing that I think annoys some people, but I freaking love. I love
At this
it.
point in time, I'm not expecting either one of them to write a report.
Let's
I
explore it.
expect a couple of exhibits. Some will be things from the protected materials that the court allowed us to have already. There will probably be 1 or 2 other exhibits, maybe 2 that the state hasn't seen before. I can provide those. I intend to provide those. On the hearing on the 14th, I think there may be 2 witnesses. On that hearing, 1 for sure, possibly a second. We haven't made that determination yet. If there is going to be any PowerPoint presentation, I will provide that to the state as well.
Sorry, I feel like something. The telling you guys what that hearing, Santa, and that jury dude. Some crazy shit happened in that courtroom between the 2 of them. And did you hear how Santa the way he specifically said the PowerPoint presentation Oh my God, you guys. And then that's why it's really funny that now she's like, if there's going to be another PowerPoint, we'll provide that as well.
If we have an expert who hasn't written a report, then we won't offer expert opinions. We'll offer opinions about why we know the discovery is available, why we know these items are available. The state knows full well what they have and what they're withholding from us. And it's not going to be about what they're going to show. We don't know what they're going to show, but we know they exist.
Thank you. Well, I just want to have this hearing. I don't want to push it out. All I can say is do your best. I'll be fair about it. I'll give you more time to respond.
Well said.
If you don't have that time, that's kind of where we are. And I just want to keep going. I mean, we got to get through all this discovery stuff so that we can get ready for the trial.
Well, and Judge, I do for the record need to clarify the representations of the defense that we are intentionally withholding things that they're entitled to is just utter nonsense. We have strived. We are continuing every week to provide additional discovery. We have more discovery coming. We hope that much of what they felt they had to file a motion to compel on, instead of being patient and wait because our discovery deadline isn't until September, that we'll have and be able to make that available between now and the hearings on the 14th. And there may very well be little, if anything, we have to fight about. Your Honor also noted there are some things that we simply do not have the power to access. And we have been trying consistently through cooperative efforts, as well as following the process with the federal government. They have been good partners, but they have their own rules to work with. This isn't the motions for the subpoenas ducis tecum isn't the first TUI process, and the court is aware. We've been pursuing TUI process for all types of information for months. So the characterization that we are just consciously withholding information to frustrate the defense is utter nonsense. That is not true. We will provide everything we can that is providable under the rules. If we disagree on something, whether it exists or not, because I can tell you many of the things that the defendant has tried to itemize, when we talk to our people, they say that doesn't exist. So, I don't know what we're supposed to do at that point. We'll flesh it out.
This is the same. I feel like I'm having deja vu. This is the same thing. This is the exact same thing. Months ago, I remember this. And it was the same thing where it was like this whole thing about they're saying there's stuff that hasn't been turned over, and they're saying they can't get it because it's from the FBI and they're doing their best to get it. But I'm just having deja vu where it's like they can't even. In other words, it sounds like the FBI, if there is more stuff, the FBI has it. No one knows. It doesn't, let me just back it up just a second to see if I can try to be more accurate with quoting this.
When we talk to our people, they say that doesn't exist.
Right. Yeah. Right. That's the part where I was like, because they said that's what they said before, where they're like, yeah, it doesn't exist. They're asking for things that don't exist. They can't. So I don't know how this argument is still going on because I remember this, and it's like, they're asking for stuff. And the whole thing was like, well, they can't turn it over if it doesn't exist. I don't know. What's he going to say?
So, I don't know what we're supposed to do at that point. We'll flesh it out at a hearing. And it may be that if they have experts who are going to say, well, such and such should exist, we might have to go find experts to say, well, in this case, it doesn't.
They're saying, Candace, they're saying
or
it
no.
doesn't exist.
We'll see.
Well, that's exactly why I want to close it on the 14th, because we're going to have many arguments, apparently, about issue by issue by issue. And some of that should not be out of it.
Thank you, Your Honor.
Your Honor, I want to respond to that, and I could give you particular examples of things. And it's already been ordered to be given to us, the CAST report, which was a draft that we were promised to have by March 31st. It's May 2nd. We don't have it. So for the
They want that for the alibi. And remember, the prosecution made a motion just recently. We went over it. For Judge John, oh my God, for Judge John Judge to say no more. You've run out of opportunities to do the alibi defense. There's going to be a number of filings dropping on this any day now. Because there's been so much stuff happening. Every time there's a filing, there's always going to be another filing because there's always a response and then a response to response. So there's going to be a lot of stuff dropping. Of course, I'll keep an eye on it, but it'll be interesting to see what he says about the alibi. I'm definitely looking forward to that.
prosecutor to stand up and say that I'm misrepresenting things, he's misrepresenting things, Your Honor.
Oh,
That's
You
there.
know what? Let's not go there. I mean, we can sort
Same,
that
yes.
out on the
They're
14th.
just being
I
children.
mean,
Look
I
at them
read
both
everything.
y'all. You guys, it's just like siblings. What do they say? It's like, when they copy each other, it's like, I know you are, but what am I? And then it's like, I know you are, but what am I? And they just copy each other and all that. You guys know what I mean? What is that? Like, you just copy what the other person says type thing. Let me back that up because that's really fucking funny what she says. And my reaction, and then he's like, puts his hands up like, no, children. Look at right there. Classic.
That we were promised to have by March 31st. It's May 2nd. We don't have it. So for the prosecutor to stand up and say that I'm misrepresenting things, he's misrepresenting things.
Yeah, right there. Like, he's misrepresenting that I'm representing that he's representing that you guys see what I mean? Like, it's just freaking hilarious.
That's
You
there.
know what? Let's not go there. I mean, we can sort that out on the 14th. I mean, I read everything. That's what the state was saying. I trust both of you. Okay, your integrity. So I don't want this pointing the fingers back and forth. I don't think it's very helpful. Doesn't really help me. It started at the last hearing, and I really want you all to just tone it down a little bit. I mean,
He is saying he wants them to stop pointing fingers at each other and for them to get along better.
You can argue all you want, but when it starts to be personal, it's destructive.
Yeah, I agree.
You're really, really good lawyers. So let's just focus on the issues.
Your Honor, we're happy to, and when we get the cash report, we'll disclose it. If we do not have it, we are not withholding it. As simple as
I
that.
read that last night. Okay. I'm fairly prepared about what the issues are, okay, about the discovery. And that's why I want to be able to hear from both sides, okay, what is the problem with this? What do we need to go forward? And I'm going to try and help that. And I expect that both of you do the same.
Your Honor, I do have several other examples, but in light of what the court said, I won't provide them right at the moment. There are other issues.
I understand, and I understand your frustration. And it's a big deal. It's
It is a
really
big
important.
I want to know what
I
it is.
understand that too, and I acknowledge that. Sometimes, we just can't quite get what we want from other people who might have it that don't want to give it up. So that's one of my challenges on the 14th. And
It really sounds like there's an issue here with the FBI, and I don't, fuck if I know how you get the FBI to do what you want them to do, but that's what it sounds like. And it sounds like if there's any being careful, that could be part of it, right? Because the state governments don't have control over the FBI. You know what I mean? And this is not the first or the only time we've heard this. We've heard this in other trials where sometimes they have difficulty getting stuff from the FBI. So I didn't hear the state say they didn't want the cast report. What I heard them say is that they've been making these requests from the FBI, and either there's things that they haven't turned over yet, that the FBI hasn't turned over yet, or the FBI says they don't have it. I don't recall them saying that they don't want that. I don't know if anyone in the chat recalls that, but I'm sure they want it. I mean, of course they want it. I think it sounds like to me they're having trouble. Like I was saying, even the judge is saying that he's having a hard time. I mean, to send that subpoena Dukas Takem, like, is what they're talking about, where it's like the court is compelling you to turn it over, but at the end of the day, it's the state versus the feds.
Probably up to 16 too. Okay. Moving on. We've got all right. Some of these pending motions, there was no request or no response from the state, and I'm thinking that the motion to unseal parts of the IDP materials and motion to allow defense investigators to review the IDP materials, that we're going to be addressing that on the 16th. Is that?
Yes, sir.
That's the state's understanding. Ms. Taylor?
Yes, Your Honor. Well, we're happy to have a hearing on the 16th for both of those issues as well.
Great. I'm just trying to make sure that we're all on the same page,
Same sheet of
or at least the same date. But I wondered, okay, there's been a response on the alibi issue, and I don't know if there is a request for a hearing, or if we just kind of let that lie for now. I don't know. What was your
right? Oh, right. The state's
What was
response. We
your,
covered that. The state's response. Right.
intention there, Mr.
Sorry, and I did just refer to that also. That's where the state was like, we don't want you to let them do any more, trying to say they can, like, put an end to the alibi defense thing. That's what he's referring to. We covered that the other live stream.
Thompson?
Santa.
I think at some point we're going to need a hearing on it. We're busy enough for the next couple of weeks with these other hearings, so we haven't reached out specifically on that.
Okay.
If the court would like to select a date while we're together today for a hearing, we would be happy to.
Why don't we just
Stick
wait
that
until the 14th or 16th?
That's fine.
And there may be issues that come out of discovery that have some bearing on that issue. I don't know. You don't have to say anything this day. Things can read your mind though. Sometimes, maybe not. All right. Okay, I'm going to sign those subpoena duces taken. The FBI. That's related. Also.
So did you guys? That's important. He's signing that subpoena, Dukas Takem, so for the FBI. So this should send them a very strong message. That's the point. It'll be interesting to see what happens after this.
So to the 13th supplemental.
And see what he's saying. If he's going to send that.
The FBI.
Hold on.
Okay, I'm going to sign those subpoena duces taken. The FBI. I believe that's related also to the 13th supplemental.
Okay.
I'm kind of losing track of it.
Your Honor, it does relate to one of our discovery requests, and I'm sure one of the numbered motions to compel. I'll note that when I speak about that on the 14th.
Okay, great.
So this could bring.
All right. Are there any other issues that we need to address today? Mr. Thompson, Ms. Jennings? Okay, Ms. Taylor?
Yes, Your Honor.
Okay, go ahead.
I want to say this in a way that doesn't come off finger pointing, because it's not.
Oh, boy.
This is about
Yeah,
how
he's
busy
laughing.
everybody is
I fucking
and
love that.
how much time it takes to communicate to get hearings set, because there's a lot of people going a lot of directions. I would like the court to consider setting hearings twice a month, every other week, And the court can vacate those hearings if neither party notices something up for that hearing. There would be 14 days notice for either party if we have hearings on that basis. But that way we could notice up specific hearings and just have those set dates so that we're not bugging the prosecutor's office for a stipulation and bugging the clerk's office for a hearing and waiting to find that out. It would speed things up to have 2 times a month that we would know if I've got 14 days before this hearing, I can notice it up and it can be heard by the court. So that's our request, is that the court just reset a couple of hearings. These would not be like the lengthy motions to suppress that we'll probably need a couple of full days for. These would be these shorter motions that we could deal with in 1 to 2 hours.
All right. Thank you. I actually mentioned that at one of our hearings. That's what we need to do. I think it would be more helpful to, I guess, have better communication. Okay. I don't know. Maybe you are having good communication with each side. It is hard, to get a hearing when the clerk has to contact you or contact Mr. Thompson, and this goes back and forth. I mean, it takes a lot of time for your assistant, the clerks. At the same time, I have a lot of other cases, and I have a lot of jury trials going from here really to the end of the year. So
here's what I'm
it's
hearing.
hard for me to say, okay.
Here's what I'm hearing from him. This is completely reasonable. So here's what he's saying. He's saying, okay, these two sides are arguing about literally everything. And the thing is that for those of you who may not be aware, there are expectations, like when you've got these trials, right? That the two sides, even if it's civil, doesn't matter. They're supposed to communicate with each other and not need the judge. I mean, again, think of like siblings, right? They're supposed to be able to work some things out on their own and not need the parents, aka the judge, to weigh in. They're supposed to be able to, right? And so the problem here that I think he's sort of hinting at is that they're arguing over everything and they aren't able to solve these issues on their own. And there's a million filings and they're requesting hearings for every type of filing, every issue. And so Ann Taylor is suggesting that they schedule just like regular hearings, like twice a month or whatever, just going forward. And then eventually they're going to need more and do that on a regular basis, which is unheard of in my experience. I've never not heard of that. Maybe leading right up to trial, but this is really unusual. The number of hearings they've had already was already unusual, and it wasn't at that point, they weren't even on a schedule. So they're saying like schedule them and then add more and just make it like a regular thing. And he's like, you guys, I have other cases. I think what he's going to be getting to here is you guys are going to need to figure some stuff out on your own. And because this is not reasonable. I mean, that's kind of just my impression of it, because it really is a lot.
We're going to have it I think I offered Thursday, like a Thursday afternoon. So I'm willing to do that. I might just set like once a month, maybe. And then if you need something more, just let us know. But I'll look at my calendar and set that up. I mean, I know you come down on Thursdays generally. So that's a good day for you, right?
Thursdays are fine. Tuesdays are fine. Fridays are fine. Wednesdays are rough, but whatever day works for the court, I'll make that work. I just think it's more important that we have a place to put these hearings so that everybody's not spending a lot of time asking each other what day's okay, what time's okay, that we just all know that this is the time. So whatever day works best with the court schedule, Your Honor, is just fine with me.
Thursday afternoon is probably
That'll work.
Monday is impossible. So what do you think about that, Ms. Jennings?
Yeah, that makes sense. I think Thursday afternoon would be fine for the state.
Do you think twice a month? It's probably going to ramp up.
I suggested that just because then there's 14 days to the next hearing, so everybody would always have enough notice. is why I suggested that. And to know that we have those to iron out issues that are going to arise. Again, these aren't for the motions to suppress. Those will come later.
Okay. Maybe we'll start with twice a month to get through all this discovery. I hope we can all get past that soon. Then move forward a little faster. Okay. Anything else then?
No, thank you.
Okay. Okay, great. Well, thank you all and have a good day. Beautiful day.
Okay.
Thank you.
All right, that's the end. So we will stay tuned and keep you guys posted on what happens. Like, again, like I said, there's going to be more filings coming out. I'm sure soon they're going to have to put in the filings, solidifying these upcoming hearings and whatnot. So I will continue, as always, to stay updated on all of that, let y'all know. And again, tomorrow we will be having our Gloria Satterfield at, I believe I have it scheduled for 7:00 tomorrow. So that will be part 3. Part 2 has timestamps and everything for anyone that wants to get caught up. That case is just absolutely insane. And as always, like I said, I appreciate y'all being here. Let me go ahead and put this back on, our little background. And I appreciate everybody that, is here expressing their, asking questions and, kind of trying to go through everything. I'm grateful for you guys keeping an open mind. And again, we are going to try to stay really, especially it's pre-trial. That's the other thing, right? It's pre-trial. So if ever there's a time to really just focus on the lawyering, you know what I mean? The lawyering and the, this is actually kind of a rarity that we get to see this much pre-trial activity. A lot of times we don't really see much about a case till it goes to trial. So this is really a great opportunity to have to kind of examine how these proceedings are working and again, assessing the argument, breaking all that down. And we just have to be patient. Really, that's what it comes down to. I think with this case, we have to be patient for a lot of stuff. But anywho, okay, there's Idaho. All right, y'all. I appreciate you guys, and I will see y'all hopefully tomorrow for Gloria Satterfield. And with that, I'll roll the outro.